for a state's accountability for a state's wrongful acts is a foundational principle of that global order. And international arbitration is one of those foundational tools in the international lawyer's toolkit that helps us keep us firmly within the rule of law. No gunboats seeking payment of debt, no nationalist dictators threatening less powerful economies, and no impunity for illegal actions or harm. Instead, international norms, international law, jurisprudence, and a forum. But now, today, we are faced with the most significant realignment of the global order since 1945. The catastrophic events that are taking place in Ukraine is a seismic jolt. It's a wake-up call. It's an earthquake. And it's a seismic moment in what has, in our view, and at least in my view, been a slow rumble over the last 10 years. And we're on this shaky ground together. And accountability is just one essential part of this legal consciousness that makes up the global world order. And international arbitration is one of the mechanisms for the peaceful settlement of disputes consistent with the rule of law. So in some ways, and I'm about to wrap up, in some ways, what we're doing is not novel. And your role in this is not novel. It makes sense to roll this out for the first time at an international arbitration conference because accountability is at the heart of international law. And often international arbitration as a mechanism is its lifeblood. Indeed, arbitration has been so ingrained in the consciousness that of dispute resolution that in the ancient world, it was actually depicted on the shield of Achilles. And I'll leave you with this one more image to kind of set the stage. Think about that. Achilles, on his shield was the depiction of an arbitration. Two people going to a market to talk to a wise old arbitrator to settle a dispute. The greatest warrior of antiquity, his shield, he is shielded by the rule of law, by the peaceful settlement of disputes. And that's the great genius of what we're trying to do. That is what we're trying to do. We are trying to stitch up the world at this very difficult moment. So we're gonna share with you the concept of accountability for the illegal aggression in Ukraine. And it calls on us all to be creative and innovative. Indeed, we have a plan, we have a concept that 94 members of the United Nations agree with. And they made that known in the historic vote on Monday. But I do have an agenda. Before I turn it over to this august panel, I do have an agenda because I hope to enlist you in our efforts to establish a reparations mechanism for Ukraine. Any reparations mechanism requires legitimacy in the eyes of the international community. And this will be part of our fight going forward. You, all of you, will need to help us stitch this up. So let me start there. I have to announce the CLE code, which is UAL22. UAL22. But let me start by asking Allison on the screen. Allison, can you just orient us a little bit on what the international legal framework is for state responsibility? How are states held accountable under law?
Thanks, Patrick. I'm so pleased to be here today, although I'm sad to be joining transatlantically rather than with you all in New York, which is a city that's very, very dear to my heart. I think as an anchor point for our discussion today, there are two basic principles to mention. So the first is a very important general principle of international law that a state responsible for an internationally wrongful act must make full reparation for the injury caused. And obviously we can dig deeper in our conversation into what that's going to look like in a particular case, but that is the basic principle, long-standing principle, general principle of international law. And that's the foundation really to everything that is being built in this mechanism for Ukraine. Now, that begs the question, of course, when is a state responsible for an internationally wrongful act? There, among other sources, we look to the International Law Commission's text the articles on the responsibility of states for internationally wrongful acts. So that was adopted by the UN General Assembly in 2001. The articles as a whole set out the general framework of state responsibility. And when it comes to reparations, we look to Article 31, headed reparation, and that has two provisions. Firstly, it tells us that the responsible state is under an obligation to make full reparation for the injury caused by the internationally wrongful act. And then it tells us a little bit about what injury means. Injury includes any damage, whether material or moral, caused by the internationally wrongful act of a state. Now, there's been a lot of international practice since 2001 that has developed the law on reparations, but as a starting point, I would put those two basic building blocks out there as a starting point for the legal framework for today's discussion.
Thanks, Alison. That's very helpful. So now that we've kind of reminded you that there are firm foundations of international law underlying our work, I wonder, Jeremy, Chiara, if you could tell us a little bit about how reparations fits into that framework and kind of what a claims commission is and what the mechanism is. And we'll slowly start to peel this open for you. And if there are questions from the audience in a little bit, just raise your hand. We're happy to take them throughout. Chiara.
Thank you very much. Well, thank you very much, Patrick. Thank you very much for the invitation. Let me just start also by saying what an honor it is to be here today and to serve in the expert group working really on this really fundamental issue on trying and secure reparation, which is really, which challenges the foundation of international law and the system as we know it. So as Alison was saying, this is really like it could be a simple application of the rules of state responsibility. There is a violation, and there's been a violation that has been recognized by the General Assembly resolution, and this violation of a state violation and the consequence, there are legal consequences, and the legal consequences include the full reparation. So how do you secure full reparations, and what are the available instruments? When we began thinking about what to look for and what kind of legal framework would exist, we thought about claims commissions. There are, at the moment, no existing international court that would have jurisdiction on these issues, but there are interesting examples of past claims commissions that really worked. When we think about international claims commissions, we have very interesting recent examples that have been constituted, have been created in the aftermath of international significant events. There are international structures, and they are very flexible structures. They can be created ad hoc, and so they can be really targeted to whatever the situation requires. And when I think about claims commission, there are three really that come to mind. The first one is probably the Iran-US Claims Tribunal, with which I'm sure you're familiar with. And this was created in the aftermath of the overthrow of the Shah. And this was a very unique instrument, was created by a very unique international instrument that was negotiated by Algeria and included Iran and US and the United States on the other side. And this was a commission that worked and is still sitting in The Hague that had jurisdiction to hear both individual claims, corporate claims, and state-to-state claims. And this is one of the characteristics of claims commission, the ability to be flexible and have jurisdiction over both individual claims and claims for corporation, but also claims from states. And that really from after the United States claims tribunal, the Iran-US Claims Tribunal, another example that I think is very relevant is the UNCC, which is very different, but really provides a very similar service in the sense that this was created by a resolution of the Security Council. And this was the United Nations Compensation Commission hearing claims that were brought very extensively by individuals, again, corporations and states, many states, in the aftermath of Iraq's invasion of Kuwait. Here, there was an understanding by the international community that something had to be done. And the UNCC really wrapped up very, very recently after acting for over 30 years and hearing millions of claims from individuals and providing compensation in billions of dollars in compensation. So a successful instrument that I think would provide interesting examples and lessons learned for something that we are trying to create here, the priority to individuals, the fact that you have vast jurisdiction and a very flexible jurisdiction. And the last example that I would like to mention very briefly is the Eritrea-Ethiopia Claims Commission. And here is very different in the sense this was not created by a Security Council resolution. This was another bilateral treaty between Eritrea and Ethiopia. But this is very different and quite interesting because it was a much smaller commission that acted for a much shorter time, but had jurisdiction to hear claims also on violation of international humanitarian law, which is what we're having here also. So this is quite interesting because what I would like to say before concluding is claims commissions can be very, very flexible and can really be targeted. Here we have violations of many different norms of international public law, international environmental law, international economic law, international humanitarian law. And when we're thinking about creating a commission, we have to think about this. We have to think about who the claimants can be. And here we have individuals, we have corporations, and of course we have the state, and what kind of possible claims there are. I think we can talk about all this in the next couple of minutes.
Yeah, and for those of you kind of paying attention, all of those examples that Chiara just mentioned are examples that existed after a dispute, after an event took place. We are currently in the midst of this crisis, and they all included states that had, in some ways, manifested consent to these processes, and we do not have that here. So there are some unique challenges. But Jeremy, I wonder if you could help peel the onion a little bit more and start kind of explaining kind of what are some of the key features of these claims commissions. In addition, Chiara mentioned one, which is flexibility with regard to the kinds of claimants, but what are some of the other features that figure in these commissions?
Thank you, Patrick, for the introduction, and thank you, of course, for the organizers for having us here. I want to just follow up first on one thing that Chiara suggested, which is why is Ukraine seeking a claims commission here? Why do states create claims commissions in the first place? I suppose, to generalize the matter, they do it when they're necessary, when they're deemed useful, and when they're feasible. That is, when are they necessary, right? We think about the way that states resolve mass claims traditionally. You either have diplomatic protection and espousal for claims, or you have lump sum settlements where two states will negotiate a settlement agreement, and then the receiving state will deal with the payment, like through the Foreign Claims Settlement Commission. But here, we don't have the possibility to have a lump sum settlement. An international court is not available. There's a case in the International Court of Justice, but if you look at the Congo-Uganda case, you see the real problems of trying to get remedies when there are tens of thousands, hundreds of thousands, or millions of victims. The ICJ is not set up to act like a claims commission. And at the same time, domestic courts, whether in Ukraine, the US, or some other place, are not available. So they're necessary. Sometimes they're useful, right? It's not just about providing compensation for individuals, but states can have broader interests in creating a claims commission. And the great example is resolving an international crisis. Both the Iran-United States Claims Tribunal and the Eritrea-Ethiopia Claims Commission, and even the UNCC, were integral parts of restoring international peace and security, or in the case of the Iran-US Claims Tribunal, an integral part of the resolution of the hostage crisis. But there are other interests that states could have. President Zelensky, when he announced his government's interest in having a claims commission, also mentioned deterrence. We need an effective mechanism to deter not just Russia, but other future aggressors, that these violations of international law and acts of aggression have consequences, including financial consequences. And then there are other issues like accountability, reconciliation, and so forth. that could be part of the utility calculation of a state. And the third, I would suggest to generalize, is feasibility. There has to be the feasibility of creating a mechanism, legal feasibility, practical feasibility, and financial feasibility. For instance, if you look at the Iran-United States Claims Tribunal, why was it feasible? Because the United States was holding $12 billion in Iranian assets. It gave it leverage in the negotiations, and it gave it funds for a security account. The United Nations Compensation Commission could rely on Iraq's, a percentage of Iraq's oil exports to pay for awards of the UNCC. And on the other hand, the inability of Eritrea or Ethiopia to provide funds is one of the criticisms of why that institution was not, in the end, feasible, created, but not that feasible in the end, but still useful because it helped resolve a bloody border war that had killed tens of thousands of people and threatened stability in the Horn of Africa. So you can't just evaluate the reasons for a claims commission or the success of a claims commission based on a narrow metric, I think, of just financial payment to X number of claimants. So why do we create these things? What are some of the other reasons, the features that Patrick mentioned? These are bespoke instruments. You're creating an institution that allows you to have compensation for particular claimants, where you can define the claims categories. You can have a particular class of claims that you can define. You can have bespoke evidentiary principles to make sure that it's not like an ordinary arbitration where you might have specific rules about each party's obligation to provide evidence to make its case, but you can have different evidentiary principles that allow effective reparations in circumstances arising out of war, revolution, riots, and so forth, where this otherwise might be very difficult to provide any kind of remedy for victims. So I think from my perspective, one of the key reasons or the key benefits of looking at a claims commission in this context is the bespoke nature of an institution. You create the institution to fit the circumstances that exist, rather than trying to fit these unusual circumstances into an existing institution where you may find that it's wholly ineffective.
I mean, thank you, Jeremy. That's a great segue to Mark-Jan. So Mark-Jan, tell us how we are creating this bespoke, fit-for-purpose mechanism. What's the concept? What have you guided us all toward? Tell us a little bit about this building that we as architects are creating.
Thank you, Patrick, and good morning, everyone. Thank you to the organizers for having this panel and this discussion. I'm glad that we timed the resolution just right so we can discuss it today. But it's a big challenge to build something new because law is set in its ways and institutions are set in their ways. But sometimes there are circumstances that just dictate the necessity of that. And unfortunately, this war has become a circumstance like that. When the war started, all the lawyers in Ukraine, myself included, immediately started thinking of ways, just a professional reflex. So how do we sue Russia for all this damage that Russia is causing? And in thinking that, we quickly realized that in our normal practice, we have one particular client, one particular case, one particular set of facts, and we try to find jurisdiction that fits that particular client and case and set of facts. Our challenge is different because we have effectively millions of clients with different sets of facts. We have teeny tiny clients, we have individuals who have lost their possessions, and we have the government who has lost massive amounts of infrastructure, and we have businesses that have lost their facilities. So where do we go to, or what jurisdiction is there so that everybody could file their claim there? And obviously we very quickly ran out of conventional options. All the courts, all the arbitration tribunals obviously don't fit for the purpose, whether for jurisdiction or immunities or subject matter or difficulties with enforcement. There just wasn't anything there that worked. And we realized that we have to make something new. And thankfully, in making something new, we have a lot of examples of all these claims commissions that Chiara and Jeremy have talked about that have followed conflicts like that, wars, armed conflicts, and other crises that we could use as an example, that we could mold into what we basically need to address this challenge. When we got to that thinking, we realized that we have another problem that comes with the way how those things were established, because fundamentally, historically, there's only two ways that can be done. One is through consent of all parties, and specifically with the consent of the party that is supposed to be paying reparations. That consent may be sort of not entirely free. When Germany lost World War II, it agreed to reparations, but not because it wanted to, but because it had no choice. But normally it's some sort of a peace agreement or a ceasefire, some sort of arrangement where parties just come together and say, okay, we need to figure out how to resolve the property related and damages related consequences of this. The other, so obviously, I mean, as I sit here today, Russia is not going to agree to any of this. I'm not saying it's set in stone and not going to change in the future, but as we sit right now, that's the unfortunate reality. The other way, the only other way in which that has been possible in the past was through compulsion. And compulsion in international law is only possible through the Security Council that can make decisions that are mandatory for execution by all member states. And that's how the UNCC was born. Fundamentally, Iraq reluctantly agreed to participate in that process, but in the end of the day, it was imposed on it. Again, Russia is not allowing us to make that happen because of its veto right in the Security Council, and whether or not that constitutes abuse is a subject matter of a whole other discussion, but the fact remains Security Council is blocked. So what do we do? So we looked at law, we looked at Article 31 of the draft articles on state responsibility that Alison had mentioned, and the language there is that the state is responsible for violations of international law, including by way of payment of making reparation. And that duty is not conditional on its consent. It's not conditional on its agreement to make these reparations, it's just there. And it shouldn't, we came to the conclusion, it shouldn't matter that Russia is blocking the ways to build this mechanism. If Russia does not want to, the community should do it themselves. Enter the idea with the UNGA resolution as a way of sort of sidestepping the blocked Security Council and issuing a mandate to the international community to build this mechanism. And it took a long time, but we got there on Monday when the member states voted in favor of this resolution. It's, in academic terms, there's nothing really new in it. There's a recognition of a violation of international law that it's pretty standard. There's a helpful recognition that that carries a duty to make reparation, and there's a need for a compensation mechanism built into it. I cannot take credit for this quote. This was something told me that folks that worked on the draft articles, people at the ILC, sometimes complain that with the draft articles, there's a little bit of a Santa Claus problem, because everybody knows that the articles are there, but nobody has seen them in action. So in the matter of speaking, we like to think that in this resolution, we proved that Santa Claus is real. Because for the first time, as Patrick said, we have these things written down in plain language in a convincing instrument that if there is a violation of international law, it carries a duty to make reparation, and Russia must be held to that obligation, and the member states, regardless of Russia's consent or lack thereof, should there is a need for them to come together and work to establish that mechanism. So we have that, and as we say for the architects, that's where the real work starts, because it's one to design it, and now we have to build it. And from this point on, we are proceeding to building it. And there are two elements to it, at which point I'll stop with these remarks. One is the mechanism itself, the adjudicatory body, the claims commission, in whatever form it will be. We don't yet know. It will be up for negotiations between Ukraine and those states that are willing to participate in it. But that's the adjudicatory process that will determine the scope and size of reparations. But preceding that is the register of damage. That is a system where claimants can submit their claims and evidence of those claims without having to wait these months and years while the mechanism is being set up, to prepare that claims, to record the evidence, not to wait for them to dissipate, to be forgotten, lost, destroyed in the ongoing war, to make sure that there's a clear scope of what is being claimed, a clear scope of evidence, so that the evidence collection is organized, coherent, there is no overlap, and more importantly, no gaps in the evidence collection process. And these are going to be our immediate steps in order to build that system. I stop now.
Thanks, Mark-Jan. It's a tremendous achievement. Congratulations. I think one, just to kind of continue to peel this onion and go a little deeper. I don't know how to work Santa Claus into what I'm about to say, but I think the commission, as we understand it, right, would serve three purposes. One, adjudicating claims for compensation. And there are a number of questions as practitioners that might immediately pop to mind, like, well, what does that adjudication look like? How many judges? What's the evidence? What's the standard of proof? All of those questions. And by the way, it's our job to figure that out, right? Two, paying awards, right? So another question that you might have, how is this thing going to be funded? How will those awards be paid, right? But the commission needs to figure out a way to pay those awards too. And then three, a means of enforcement, right? How do you domesticate these awards? How do you bring them home? Or how are these awards recognized globally? Is it a New York Convention kind of thing? Is it another convention? Is there a different treaty that needs to be drafted that gives a characteristic to these awards that will allow them to be recognized? I mean, the Iran-US Claims Tribunal, for example, those awards are recognized, right? So so we can talk about all of those things. And then the other thing that I just kind of wanted to put on the table, and then I'm going to open it up to folks who have things to say, is the damages registry. I mean, the immediate next step, right? The UN General Assembly resolution actually called for the creation of a registry of damage. And that's significant. So we now have a mandate from 94 member states, well, really the world, to create this registry and to populate it. And you, practitioners, need to start thinking about how we're going to gather, put evidence in, perfect those claims so that they remain viable for when this mechanism is up and running and paying compensation. So let me just throw those out on the table. So one, I'd love to hear folks' thoughts on challenges to adjudication, the challenges to payment, and the challenges to enforcement. And I'd love to hear, maybe, Jeremy, we could start with you just on evidence. I mean, evidence itself is such a challenge. We have, in some estimates, close to $1 trillion worth of damage. We have, for the first time, real-time, second-by-second satellite imagery cataloging the damage that Russia is causing. But conceptually, how do we accomplish that? I mean, those of you who are old enough to remember doc rooms, where you walk into a room and there's a bunch of boxes and you have to go through them. I mean, we're talking about unfathomable amounts of data, right? Jeremy, evidence. Easy question. Or Allison, jump in at any time. Okay.
I do think that's one of the main challenges. Obviously, if you're dealing with millions of claims, you can't approach this in the way that you would in ordinary arbitration. I think this is one of the challenges, for instance, of the Iran-US Claims Tribunal, where you have the tribunal adopt the unsubstantial arbitration rules, not because they were old and tested, they were new and untested, but they were deemed neutral. And I think the United States thought that the General Assembly, having approved unanimously the rules, they would be acceptable to Iran. But it does require each party to provide the evidence to make its claim or defense. And I suppose some of the individuals who had been involved at the Iran-US Claims Tribunal, when they moved over to establishing the UNCC, recognized that when you have orders of magnitude of additional claimants, you can't have that traditional adversarial adjudicative approach, that we needed a different kind of approach. I suppose the two innovations of the UNCC were, first, to have the Security Council determine under Chapter 7 that Iraq was liable for all damage directly caused by the invasion and annexation of Kuwait. And second, that there needed to be a relaxed standard of proof for smaller claims like forced departure, serious personal injury, simple documentation of facts, no evidence of quantum. Because these were relatively small in amount, they were fixed sums, and if you're dealing with 1.5 million claimants, you can't have, obviously, the kinds of evidentiary standards that you have in an ordinary arbitration. And I think that set the stage for later claims commissions to build on that, and then to think about, well, what additional evidentiary challenges might claimants face, thinking about claims arising from World War II and the Holocaust, for instance, and taking it a step further. So what can you do? You can provide an affirmative obligation of one party to provide evidence. For instance, the Swiss banks had to come forward with evidence about these Holocaust-era bank accounts rather than relying on the claimants to be expected to try to find this information. You can impose an obligation or a request of the Secretariat to do some of the claimant's work, to, for instance, to go to the German archives themselves and to gather all the evidence about forced labor to help claimants make their cases. You can build into the rules a signal to the decision makers that they shall take into account the circumstances in which they're deciding claims, including the long passage of time and the circumstances of war and the Holocaust and so forth. And there are evidentiary presumptions, which are also important. If you think that there will be difficult issues of causality or gaps in the proof, you can build in presumptions. So for instance, if you were a person of a particular religion or race and you worked in this factory at this time during World War II, it is presumed that you are subjected to forced labor. You do not have to provide affirmative evidence that you weren't paid those 70 years ago or whatever. So I think each claims commission, again, gets to think about what are the nature of the claimants, the nature of their claims, the evidence that you could reasonably expect these individuals to have given the circumstances in which they might have had to flee Ukraine, and what other things you might do to help them to ensure that actual victims are compensated with adequate protections, basic due process protections. But many of these more recent claims commissions have been characterized as more rough justice than very traditional sort of arbitrations with the ordinary burdens and standards of proof.
Chiara, you wanted to come in on this?
Well, actually, I'd like to kind of maybe take on the other question that you had about challenges to adjudication a little bit, but just to expand some of the issues, because I think when you're thinking about challenge adjudications, you have to think about, so who are the claimants, what are the claims, and who decides? And I think here it's reasonable to expect that we're going to have millions of claimants and millions of claims that have very different claims. And I think it's interesting then so how do we manage these claims? And there are some lessons learned, I think, from past claims commissions. So for example, the UNCC divided claims in different categories. And the categories included categories that were only for individual claims and others that instead were for states. And those individual claims took priority. And I think this is something important, but also two interesting things. One is that they were mostly compensated for on a set amount. So one only had to prove in terms of evidence, as Jeremy mentioned, how do you prove the injury? Here in the categories for the UNCC A and B, these were set amount for those who had to leave Kuwait. And here you have a very similar category of claimants also that had to leave or were forced to leave their houses. And so here, what was needed was just a a passport or just an evidence that they had to leave, and there was a set amount. And where also most of these individual claims, that again were millions of claims, were decided by mass claims processes. So so very expedited. And I think this is an important lessons learned that we should just think about. For the others, more complex and large claims, then you had a process that were more similar to an arbitration. So I think this is interesting also in terms of challenges of arbitration. The numbers is certainly a challenge. And then the other one is who decides, very briefly. Who decides? Here again, you can have very, very different kind of decision makers. We have at the Eritrea-Ethiopia Claims Commission was only 5 commissioners, and they were required, because of agreements of the parties, to decide in a very expedited fashion also. They could have used mass claims processes, but they didn't. But they had a very short deadline to decide. And here, again, is it something that is possible to do? Do we want a large, in the UNCC, you had, I think, 19 groups of commissioners that actually decided, and then the governing council, which mirrored the membership of the Security Council, would provide also some supervision. So you can have again many different kinds of frameworks that apply. And I think because of the number of claims that we will have, and the numbers of claims and claimants we will have, you probably need to have different decision makers also.
And the number is enormous, right? I mean, you could imagine that every Ukrainian has suffered damage here. I mean, you don't have to imagine it, they have. And that's enormous. And for those of you in the audience who are millennials, and you come to these conferences and you're like, okay, well, everyone's, got gray hair and is well studied, and what do I do? Like, I'm just starting in my career. Well, we need to figure out what AI looks like in this space. We need to process a lot of these claims on the cloud. You have a voice there to innovate. We are at a moment of innovation, and as a younger lawyer, you need to take up that mantle. It's for your generation. That's why we called it what we called it. Mark-Jan, do you have some thoughts on this? And then I want to go to Allison.
Oh, absolutely. And I just want to pick up on what you said and think about what it means to have this problem and this process in the 21st century. If you take just one category of possible claims, forced departure, in Ukraine, you have at least 13 million claimants. 13 million people that were forced to leave their home, whether to move to other parts of Ukraine or to go abroad, or were forcefully deported to Russia. So there's 13 million claims with evidence that we'd have to process. Now, I had a pleasure of attending a class, Patrick's and Jeremy's class at Columbia Law yesterday, and John Crook was speaking there. He has a lot of experience working in all these claims commissions, and he said a very important thing, that a fundamental need of these instruments is that they have to have capacity to do anything within the lifetime of the people affected. UNCC has worked for 30 years. I'm sure there were victims of that war that had not survived, had not lived to see compensation and justice. And we need to avoid that. All that is to say that it's difficult to work with evidence of that size and scope. Therefore, we need to find a way to look at evidence as data and find ways to process that data without, a comprehensive manual involvement of every particular individual. So the concept that we are conceiving is to automate that process as best as we can and rely on digital form of evidence and digital form of data as much as we can. How do we ask an elderly couple from Mariupol to file a claim over an apartment that they had lost because their building was bombed? It should be very simple. When they press a button, there should be, and there is in Ukraine, a register that verifies their identity, that they verifies that they had title to that particular apartment, that there is a map service that puts a pin on the map where that apartment was. There's a satellite picture of that block in the city from before the war and after the war, where the damage is obvious. And there should be an automatic determination of, yes, that particular claim is eligible, it's viable, and it works. That's the only way to process millions and millions of claims if we want to have something done within the lifetime of the victims. Now, the challenge is how we make all that compatible with what we see as traditional rules of due process and evidence. Now, that's a challenge. I don't think that that challenge is insurmountable, but something for us to think of in the following weeks and months.
But just picking up on that, Mark-Jan, and again, I'm just going to keep hitting this point. That button, right? You click that button. That moment of clicking that button is a crucible for us as an international community. It is a crucible because that individual needs to know that international law matters and has effect. That is what keeps us safe. So we need to draw a line from that button all the way up to the foundational principles that we're trying to protect here, that reparations must be paid for flagrant, illegal action by a state against another state. And if we don't protect that macro point through the button, through that little touch point, if we don't do that, we are falling down and allowing what previous architects from 1945 have created to crumble in front of us. Allison, as someone who appears before the ICJ, what are some of the challenges you see, and you know, how are we going to overcome them?
Well, I'm going to cut to the end of the process, and I just want to highlight a point that we haven't touched on so much yet. We've touched on a lot of very, very important practical challenges, the practical reality of the couple who have lost their home, and they hopefully have a system which is seamless, which is straightforward, where they can upload their claim. And Patrick, you mentioned they press the button. I want to cut forward to what I see as one of the challenges, if this isn't just going to set people up for disappointment down the line, which is what do they get at the end of the day, in what time scale, what do they get back? So in other words, the assets, let's talk about that for a moment perhaps. The money, this system has to be firstly funded, to be set up, to work, but even more importantly than that, there needs to be assets to give to the people who lost their homes, the people who lost their lives, their family members, their businesses. And so I think the question of the assets, the question of the states who are freezing, the question of the mechanism for the frozen assets to be transferred to this mechanism, the quantity of that, the ongoing work that can be done to increase that amount, the worldwide search for that, dare I say, the question of immunity, the identification of which categories of assets can be used for this mechanism, legally how they get given to this mechanism, so that there is obviously a tremendous amount of thinking, work, and creativity that has gone on to date on that. But I see that as the ultimate test of success, is getting the assets that are rightfully put into this mechanism into the hands of the people who are, under the very general principles I mentioned at the outset, entitled to those assets. That's what I see as both the biggest challenge perhaps and the litmus test for success.
It's very well put, daunting, but very well put. Why don't we, I'm not really sure, we started a little late, so I'm not really sure where we are in the life cycle of this panel, but let me open it up to the audience at this point and the invisible college of international lawyers, or maybe now the visible college. So if folks have questions, maybe just line up at the microphone or just come up and we'll take a few and hope to answer them as best we can. Sir.
We haven't really considered the point of view of
If you could just introduce yourself, that'd be great.
Kevin McMullen. We haven't considered the point of view of Russia, which is a great power and a permanent member of the Security Council with a veto. And it seems to me the question they're going to raise is, what's the original sin in this situation? Wasn't it the violent overthrow of a democratically elected government in the Ukraine? And then they're going to say That resulted in the oppression of the Russian-speaking population in the eastern Ukraine. And eventually, we had to intervene to protect those people, a humanitarian intervention, which involved warfare, but is going to allow them to assert their autonomy. And after all, the fundamental purpose of the UN Charter is to prevent another world war between the great powers. And Russia has devices to defeat sanctions in the long term, principally through China. So let's go back to the start. What's the original sin in this situation?
Sir, I think the overarching response to your question is that we are, I figure, predominantly lawyers here. And as lawyers, we are trained to speak in evidence and not in bits of propaganda. Evidence is that Russia has launched a war of aggression. Regardless of what had happened before, Russia has decided to redraw internationally recognized borders by the use of force. Period. That's the original sin. We can debate what happened before, and evidence there is that there was no illegal overthrow of government. There was a peaceful protest in Ukraine during which that particular government opened fire on peaceful protesters. Everybody likes what's happening in Iran right now because people protest against their violent government. That's exactly what had happened in Ukraine. At a point of weakness in Ukraine, Russia went in and occupied Crimea. It used proxy forces to occupy regions in the east of Ukraine, and the world was okay with that. That also may have been a sin, but it was all Russia. And please, if you want to debate at this conference, let's debate on the basis of evidence and not on the bits of information that the Kremlin media feeds to people. And it really pains me that we have to talk about this in this event.
David.
Thank you, David Rifkin, and thank you all for the great work you're doing. Just on the point of evidence, I want to mention a potential trove of evidence. The International Bar Association set up a number of years ago an app called the Eyewitness to Atrocities. And as you may know, it provides on Android phones the ability to take videos, photos, sound recordings, and it embeds in them metadata so that it can be used as direct evidence in court without a witness to verify the information, because the metadata shows that it hasn't been tampered with. The user immediately then places it in, hits send, and it goes into a database maintained by LexisNexis. And so there's chain of custody that's also clear. The IBA has been working with many in Ukraine to develop evidence, and there's quite a lot of evidence that's already going to the public prosecutor and others for other types of remedial action, prosecuting those who ought to be prosecuted. But that may also be a trove that the remedy mechanism is going to be able to use as well. And happy to work with you in connecting to the IBA and the Eyewitness Project.
That would be fantastic, and thank you for that. This is exactly what we hope the international community will do, is find ways to kind of use existing tools and innovate them and make them fit for purpose. I think that that's an excellent example, and we've seen it in other instances too. Jus Mundi, for example, is now free to anyone working on this project. Just Security has decided to translate all of the articles that they have about these issues into Ukrainian so that it can be read. So people are working. So think about in your own world kind of what you have access to and how you can contribute. Other questions, please, Guido.
Yes, and good morning. Thank you very much for an excellent panel and, of course, for your work. Now, very briefly, one of the challenges for the Commission you mentioned before will be a recognition, and you mentioned briefly the New York Convention. That's normal whenever we have a debtor that is not willing to comply with the word. That's a normal practice. However, in this scenario, we will see, of course, it's premature to talk about today, but the more the funds will come not from the official debtor, which is Russia, the more the funds will come from other sources, the less we will have a real enforcement of whatever decisions, awards, or we will see on the assets of the debtor. So that portion of the typical debate, recognition, whether or not we rely on your convention, for that part of the funds, that part will not be a reality. For the remaining parts, certainly. That's all. Thank you.
Thanks. So let me rephrase that and then open it up to the panel. Not rephrasing it because it wasn't eloquently put, but just to kind of conceptualize it. It's the question of the source of funds being an essential component of what accountability means, right? If the funds don't come from a culpable party, what is accountability? I wonder if anyone on the panel, Allison as well, has some thoughts on that. Mark-Jan, you want to start?
Sure. I think I'll start by saying that the concept that we have is a sort of a sui generis closed cycle system that should not in principle have to rely on existing instruments that are not really fit for that purpose. So the New York Convention, I think, was more as an example rather than a tool that we expect to rely on. Therefore, the concept also has elements related to, and echoing back to Allison's remarks, to how do we fund this whole thing. And assets are just one element of it. We may think that Russia's participation in this is unreal as of right now, but things change. 9 months ago, we all thought, or most of people, I should say, thought that Russia would conquer Ukraine in 3 days. Now Russia is retreating from the territories it has occupied. So things do change. And once Russia maybe wants to reintegrate itself into civilized world, maybe it will be a condition to take responsibility and to start funding this system. But the point absolutely stands. It has to come from the culpable party, because otherwise, what's the responsibility? Just to slap a label that you're responsible? That's not enough. There has to be a meaningful responsibility that will also serve as a deterrent for future instances that will help like that. And one bright example of that conflation that we sometimes hear is to the people say, like, let's make this compensation fund that Russia would hopefully put their assets in it, but also donors would pour money in it. And we are saying that, oh, hell no. This is a completely different thing. If donors want to participate in helping Ukraine rebuild itself, they can do it in some other way. There are ways to do that. But this is to hold Russia accountable.
Professor Berman?
Thank you, Patrick. I have a narrow question and then something else. The emphasis so far in the remarks were understandably on property, and Allison referred to lives. I know decisions haven't been made about what exactly is going to be compensable. That's down the line. But it would be interesting to know if there's been any decision-making or thinking along the lines of, call it wrongful death. It has the word wrongful in it, so wrongful acts include wrongful death. The other thing I wanted to mention, Patrick, particularly to you, is that you said something about this being a task for a young generation. And I wanted to invite you, because I think it's a good example, if you would, to say something about the contribution that you have caused students to make. Because people here are probably thinking about ways in which they can do things. Well, one species of things that can be done is what you're leading. And I think it would be interesting to the audience to know how you have enlisted students and what you've enlisted them on. So that's an invite.
Absolutely. I'll handle that one quickly, and then I'll throw it over to the panel to kind of talk about categories of claims and kind of what we're thinking. But George has thrown down a question for me to pick up, which is how we've involved students. And one of the most generous things that I've seen from an institution is what Columbia offered in creating the International Claims and Reparations Project. As part of that creation, Jeremy and I are teaching a practicum at Columbia. And it's important not only to kind of mention that generosity, but also to say these students, and they don't necessarily need to be Columbian students, but these students are remarkable. They are coming at this with fresh ideas, an indefatigable amount of energy. And it's kind of a privilege to see, and they are seized with the reality that this is going to be the rest of their lives. They are seized with the reality that this is a 40-year process. This is a not the compensation aspect being 40 years, but that the stitching up is going to take years and years. We're rebuilding something, and it's just remarkable to see students' participation in that, and that should be replicated everywhere. I know Chiara is doing it at Richmond. We just had a lot of interest at Harvard and elsewhere, and that's an indefatigable resource. So those of you who are adjunct professors or full professors at your institutions, please do reach out to your students and get them involved and thinking through some of these issues. It's important. But one of the issues that we've been thinking about is what claims are compensable. So maybe Chiara, do you want to mention kind of what we're thinking?
Yeah, and also maybe go back. Thank you. Also go back to the history and what has been. What we learn also from the past. Thank you for your question before, but when you're thinking about different kinds of individual claims, for example, so the big difference is individual claims and how to categorize all the different injuries that were suffered, that if you think about the UNCC, you had the category A that had a fixed sum amount for those who had to flee. And so here, of course, we have the same thing, either rather misplaced within Ukraine or had to leave, were displaced, completely had to leave Ukraine. But also category B was claims for serious personal injury and or death of an immediate family member. So here you have different kinds of categories, and again, you can approach the same in the same way categories here.
I mean, death is a compensable civil wrong.
Mm-hmm. Yeah, we have many different categories of international law obligations that were violated. So, and I think each one could be seen as a different claim.
Sir.
Thank you so much. I'm Alejandro Martinez, candidate at Cardozo Law School from NYAW. And my question is more about, I found very interesting that commission. And I wanted to start saying that, in my opinion, sometimes analyze a word just from the perspective of state A invades state B, something the surface. And I was thinking more in Africa, not in Ukraine, for example. From the end of the World War II, we have seen a lot of proxy wars where there are like two big nations that they decide basically to boost a conflict just there to get resources or whatever. So my question was, to what extent could we open that kind of claims to nations that basically are promoting a conflict in a third nation? Because sometimes we don't see that. We just see that in media. Sometimes international or political students, political science students or international relations students study those things, but not from a legal perspective. So my question was that, should we open that kind of claims to countries that promote proxy wars, for example?
I mean, I think we need to, I'll open it up to the panel. My own view is we need to remain moored in what Allison told us at the beginning, which is the basic principle of international law, that when a state commits an internationally wrongful act, it is responsible for that act. And the innovation that Mark-Jan and the team has done is put in a resolution that reparations through a mechanism are needed. So that's a principle of international law. You're a law student, and almost, and it'll be your job as a lawyer to find application of that law, right? Any other thoughts?
I'll just add to that, just to say that the best way to do it, and that's maybe the difference between law students and political science students. Law students know that you follow the law. And if the law and evidence follows follows us to the conclusion that a third state is involved, then there's no reason for that state not to be accountable, and that would be in accordance with the law. I mean, it is in the law that, for example, a state that is providing support to a state committing aggression, for example, by offering its territory or providing resources, is liable for that as well. So we can just take the same approach and just try not to use political consideration and base legal accountability on them.
Sir.
Hi, Mark Beckett. I just want to say thank you to all the members of the panel for your leadership on this critical issue. You mentioned AI, and without sounding like a crypto bro, I wonder if you've also considered private blockchain network, which would seem extremely well fitted when you have this number of claims and so much evidence and data that you need to manage. That would seem to be something that you should give some due regard to. I guess the other question I would have as well is, what happens, as we might anticipate, if Russia does not participate and doesn't come to the table at all? Does the nature of the commission change then from being more of an adversarial claims resolution process to more of an inquisitorial type of investigative process, where it is then empowered to make decisions in something more or less, I guess, like a default proceeding, but perhaps something more as a investigative committee, and then render judgments?
So can I just ask what a private blockchain network is?
It's I'm not sure I'm the person to describe it, but it's different than an open public blockchain, in that you would have a limited number of people in the network that would be able to access it. You could have a public blockchain as well, but I'm not sure that's the right approach here.
Got it. Thank you. Jeremy, I wonder if you want to kick us off on the question of recalcitrance.
Yeah, it's a great question, Mark. Thank you. I suppose if we look at historical precedents, we have some claims commissions that are reciprocal, two parties with more or less equal bargaining power that are seeking to perhaps prosecute and defend claims, like the Iran-US Claims Tribunal, and you have a traditional adversarial adjudicative approach. But a lot of claims commissions are unilateral or even coercive, right? And particularly if we look at even some non-coercive recent examples, we see more administrative claims processing. Here, you have a question mark over Russia's participation. When you think about the example of Iran, Iran didn't decide to conclude an agreement, the Algiers Accords, until very late. They needed access to the funds. They'd been invaded by Iraq. The situation changed very quickly, and it became advantageous, presumably, for Iran to agree to this mechanism to resolve these claims. One of the things, I mentioned some motivations of states, including claims agreements. Legal peace has certainly motivated a lot of actors. The ability to have a process to resolve claims in a coordinated way, in an organized and centralized place, to get legal peace, to avoid the possibility that they are legal outlaws in perpetuity, to return to capital markets and to lift the sanctions and so forth. So one overarching question is, how do you design a process with a recalcitrant party that may at some point wish to participate, and how do you keep the door open to make that a meaningful opportunity to advance the interests of the victims by, for instance, making it such that it's attractive for that entity to continue funding? And it would make a difference, I think, in terms of how you think about the claims resolution process from the outset, exactly as you're suggesting, Mark, adversarial or administrative, inquisitorial, you mentioned. And I think given the nature of the claims, the number of the claims, there will always be a large administrative element to this, but you could imagine an adversarial element for those claims, for instance, corporate claims, for instance, where the parties have the resources to prosecute a claim, the ability to gather evidence and so forth. And of course, the question of priority to provide the compensation to the individuals who are harmed and need the money first, the way that was done at the United Nations Compensation Commission, through administrative practices, and then have an adversarial practice perhaps later, all with an idea that you have a recalcitrant party that may at some point find it useful to join this process in order to advance its underlying purposes.
Can I just make a short addition to that? I mean, just by way of a light-hearted joke, the crypto bro in this process is Russia, because the other day, the Russian ambassador to the UN and the Security Council said that the FTX bankruptcy was linked to Ukraine and that the $1 billion missing was used to buy weapons for Ukraine. I mean, he really said that. I'm not joking. But on the serious side, as you may have understood, the intention is to make the whole system digital. And when I talk about this, I'm using the far fringes of my intellectual ability because I mean it's just way over my head. But the way to deal with that is that we will have a study that will basically a report that will tell us what exactly do we need in terms of a tech system, what elements of it, how to build it up. Because I don't think that there is a precedent that we really can rely on with that respect. So I expect in that study, we will have all the options sort of reviewed and studied, and recommendation will be made to Ukraine as to how to build it. And if the recommendation is to go the blockchain way with all the obvious pros and cons that come with it, then I see no reason why it shouldn't be the case.
We have about 15 more minutes, so keep those questions coming, please.
Hello, my name is Wakatani Gucha. I'm a current LLM student here at Fordham School of Law. Until this summer, I was in Russia working for Japanese companies, and when the war started, lots of foreign companies left, and there was enormous damage done to the business of foreign entities. But the truth is, while that was going on, Russia always found alternatives, and then they survived, especially when foreign companies left, when they sold business to the local entities. What do you think will be the next step from the international trade's point of view to really cause crucial damage to Russia and stop their aggression?
Well, look, I mean, our mandate is to ensure that victims in Ukraine are compensated for the damage Russia caused. Obviously, that is our project is a project of accountability, and your question gets at that principle. And there are a number of ways that you can look at accountability. One of the things that geopolitically the G7 has decided to do is to use non-kinetic force to push back on the kinetic force that Russia is using against a democracy. And that use of non-kinetic force, sanctions, freezing assets, removing them from SWIFT, is one tool. It's one significant tool. Private companies who have made the decision that it is no longer in their interest to remain in a market that is capable of perpetrating these crimes, those are for private actors to decide. But I do think that the question that you ask is one of accountability, and we are focused on ensuring one part of that accountability, which is reparations for the actual victims in Ukraine. I don't know if anyone else wants to come in on that. Sir, thank you.
Hello, everyone. My name is Carlo Monti. I'm from Fordham University. I'm an LLM student. I was wondering, you briefly touched upon it, but I was wondering if you can expand more. Let's assume you managed to get a court with jurisdiction. You managed to bring all those claims, and the court rents you a seizure on an award. How do you actually enforce that decision on a country which is, well, I don't want to say a superpower, but still a very powerful country, unless, I don't know, you invade and completely defeat Russia, but I don't think it's going to be the case. How do you actually enforce those decisions on countries?
A legal question, enforcement, how do we do it? Allison, do you want to start on enforcement, and then we can go around the table and give views on we have thought about this, so that's good. Allison, enforcement.
Is the question enforcement of how would an individual enforce a determination that they were entitled to a certain sum of money for the damage that they had suffered? Because obviously that would be a matter that would, funds ought to come through the mechanism that's been set up. So then the question really is how the prior question of, how does the mechanism get its hands on the assets of the states in the first place? And we know, of course, that many states throughout the world are, it's not a question of enforcement then in the sense that we are familiar with it from the world of arbitration, in other words, where there's an adversarial, a freestanding adversarial arbitration process, there's an award, and then there are existing treaties, there's the New York Convention, there's the Washington Convention, and you go to the jurisdictions where you realistically think there are assets and there are enforcement mechanisms there. This is really the other way around, where the force, if you like, that's applied to the assets is applied at the point of getting them into the compensation mechanism. So that's then a question of willing states taking measures in relation to assets, particular categories to be determined, that they think that there is a lawful connection between those assets and the obligation to provide reparations for an international wrongful act. So it's not then the point is, it's not down to the person who's lost their home to get some quote unquote award and have to enforce it around the world. It's down to the states who are supporting this system to lawfully gather assets to put into the system that then come out the other end to the victims. So that's how I would see the structure of it in any way. And that was just a brief attempt to distinguish that from the type of enforcement that we would be familiar with from our familiarity with arbitral proceedings.
Perfect. Anything to add, panel?
Just maybe as a point of a way to look at it is from the point of view of methodology. We're not, the idea is that the enforcement should not be the problem of a claimant. Because if it's a problem of a claimant, then every claimant, every person in Ukraine becomes a UCOS, just on a smaller scale, and has an award and then chases Russia around the world seeking for assets. No, we want to avoid that. It's a problem of the system that is being designed, and it has to be built into the design of the system. The problems remain the same. How do we get Russia to pay voluntarily through oil revenue share or by confiscating and repurposing asset? That is something that we have to work on, but it has to be built into the system, and that is a problem not for the claimants, but for Ukraine and those states that participate in making the system.
Sir.
Yeah, Paul Hook. Sometimes I have a business background too, so I want to look to the practicality. And you just went through part of it that there are billions that have been seized around the world, plus the idea with the Iraq, there was the oil percentage. But how do you do it with a recalcitrant country when you may not be able to deal with all of their customers that are buying how do you move India or China to say, yes, we'll fund a percentage of what we're paying them over, because you're probably not going to get it from Russia, at least with the current administration?
I mean, there isn't an easy and obvious way to do it. The way to think about it is to look at the oil price cap that is being negotiated and hopefully will be introduced in a matter of weeks. The price cap is being enforced by way of prohibition for traders and insurers to deal with shipments of oil that are priced above the cap. So that is the mechanism that is being applied right now. And perhaps there is a way to sort of adjust that to use it in a way that it diverts the share of the overprice, so to speak, into that fund. I'm not about to say that this is a done deal. I don't think that there's even a concept about that. I'm just saying that this is one of the ways that this has been done before, that does not require a state to pay cash out of its pockets or to give up its assets in other states. It's just a model that has been done before.
Sir.
Thank you. My name is Abiola Orakoya. I'm an HJD candidate at the Delaware Law School, and my research is on international arbitration, specifically the recognition and enforcement of international commercial arbitration awards. Before I proceed, I would like to thank the panelists for, your insights and your orientation on this issue. Assuming without considering that Russia decides to submit to jurisdiction, maybe in an arbitral claim or wherever, what are the likely defenses Russia may want to invoke under international law? Maybe state immunity. Is it possible for Russia to invoke, that defense? And my other question is with respect to enforcement of awards, whether exit awards or whatever in Russia. Are there likely sanctions or punishment for Russia for the acts perpetrated against Ukraine? Thank you.
Thanks for the question. Let's take the other two, and then we'll have all three before the panel, and then we'll wrap up. We'll take them all three together. Yep.
I'm Daniela, Georgetown Law School. Mostly, I want to ask Markian about the assets that Russian central bank and other seized assets are around the world, and if this commission thought about pulling a fund together and somehow use the respective assets, if they will exist by the time this fund will be created, to compensate potential claimants, and how to stripe the immunity of the Russian state, how to collaborate with the states around the world, and to design harmonized and convergent framework for this situation with the immunity. Thank you.
Thank you. Last question. And then
Thank you very much, and thank you so much for all your comments this morning. My name's Andrew Rigdon-Green. I'm a partner at Stevenson Harwood in London. I'm a private practice lawyer, but in another life, I had some involvement in Rwanda in post-genocide reconciliation programs. And whilst I completely understand the idea of reparations and how that has worked and not worked, or variously been successful and unsuccessful over history and how they've been imposed, I'm wondering whether there's an opportunity to be forward-looking as well, and to be weaving into the Claims Commission certain elements of, say, the style of Truth and Reconciliation Commission like we see in South Africa, so that we don't perpetuate a situation of enmity between different nation states and people who live close to each other with shared resources. Looking forward to hopefully a more global world.
Thank you. So just to recap, we have a question on, hey, what are Russia's defenses going to be if they actually participate in this process? Another question on, have you guys thought about central bank assets? And then a third question on, how do we ensure that the commission is innovative in its kind of systemic place within the global international law framework, so that we can ensure that it's a process that not only is adjudicatory and beneficial to the people of Ukraine, but also does its job to reduce the enmity between Russia and Ukraine. So those are our questions. Russian defenses, who wants to take what Russia will say? Allison, why don't you kick us off? What's Russia going to say very briefly if they do participate? It's hard to imagine.
Well, we've all run innovative and difficult defenses for clients, but I would struggle with that brief, I have to say, in light of, for example, the General Assembly resolutions on the fact that it seems to me, it's been authoritatively determined that this is a war of aggression. It flows from that all force used in that war of aggression is unlawful. In light of that, it would be a stronger lawyer than me that would pick up the challenge of saying what would be. I mean, of course, what would be the response? Political, all sorts of things. Attempts to negotiate this away. Attempts to make to water down reparations as part of some negotiated settlement. I don't know. I can imagine many political attempts to make this go away. Legal defenses to saying why the person whose apartment is destroyed or family member is killed by force used in a war of aggression as determined by the UN. Why would that be legal? Why? Beats me.
Markian, why don't you handle the question about the central bank assets and immunity, and maybe Chiara and Jeremy, you could take us home with aspects of a commission that could be different than just adjudicatory, the TRC concepts, et cetera.
But I'll use my mic access and just go back to the previous question for a second, because if I were Russia, that just scares me to say that, but if I were Russia, I would probably try to focus on the issue of causality. I would give up the hopeless issues of responsibility as a whole and jurisdiction and accountability and needing to make reparation, and I would focus on trying to see if among the millions of claims that are going to be submitted are those that have nothing to do with Russia, that just happened to take place, in Ukraine at that time, but have nothing to do with Russia. So that's what I would do, trying to see, maybe there's a case or two that has nothing to do with that, but I'm not Russian, thankfully for that. On the issue of assets, so I'll start with the simple part of it. The compensation fund is a pretty sort of standard tool. The UNCC had it, and this is basically a pool where all the assets are being poured into, no matter where they come from, whether it's direct contributions or oil revenue share or asset confiscation, doesn't matter. And from that fund, victims are being paid out. And that goes to the previous discussion of enforcement not being a claimant's problem, because the idea is that there are assets in the fund and these decisions become self-enforceable, if that's the right word for it. How to fill that fund? We've discussed the possibility, no matter how minuscule, of Russia doing that voluntarily or using oil revenue. But failing all that, we lawyers have to prepare for the most difficult scenario, is the assets. And fundamentally, it has to be Russia's assets. Russia as an actor that is doing all this violation, all this damage, and the sort of biggest, fattest target is the central bank reserves, which brings us inevitably to the issue of immunity, which is fundamentally, I think, central to this whole challenge. The issue of immunity, I'm not about to give you a comprehensive answer because I don't think that it exists at this point, that it had been articulated fully. But our thinking is that immunity must be seen from two perspectives. One, from the point of view of international law, as a construct of customary international law that is not set in stone, that has an ability to evolve and reflect the realities of modern world. That goes to the issue, I know that's Patrick's lines that I've heard that I'm repeating. There was a time where heads of state had absolute immunity and could not be prosecuted ever. There was a time where state assets had absolute immunity and could not be enforced against, regardless of whether they're used commercially or not. Those are exceptions that are now generally acceptable. Who is to say that there cannot be another exception when the state commits perhaps the most egregious violation of international law conceivable? Should that state be able to hide behind the customary international law construct of immunity? There's a question about that. And conceivably, if there's a universal condemnation of that, recognition of that fact and condemnation in overwhelming votes by the General Assembly, by the ICJ issuing a provisional order saying that Russia's presence in Ukraine is unlawful and it should withdraw its forces, if all of that is taken into account, then perhaps there is an exception to immunity that can be invoked. How it is invoked, whether by way of countermeasures or some other way, that is a sort of a technical part of it, but that's where it goes. The other perspective to look at immunity is from the national point of view, from the point of view of states that have laws about national immunity. And that's, in each jurisdiction, the discussion is going to be different. One of my favorite topics, one of my questions that I like to debate with myself during long sleepless nights, is whether national immunity in the countries where I had a chance to review that legislation from my perspective, whether it applies. Immunity normally is seen from the point of view of judicial processes. Immunity against jurisdiction, immunity against attachment and enforcement of judgments. Does that immunity protect these assets from executive or legislative action? Big question. I don't know. It's something that I like to debate with myself. but ultimately it will have to be done. Just opening up a little bit, a sort of inside story in the UN process. Russia has circulated the notes that then they sort of outlined in the speech of their ambassador at UNGA, that all this process is an attack on Russia's sovereign assets, and that is inconceivably wrong. To which our response is, well, there is a very easy way for Russia to protect their assets. That is to pay reparation voluntarily. Nobody will talk about central bank reserves anymore.
Thank you, Mark-Jan. Jeremy, Chiara, what are some innovations that you see that could be part of a commission to ensure that we win the future? And then we'll close with just 2 minutes. You've been all very patient.
Thank you very much. Can I take actually my privilege, like maybe Mark-Jan, just to say something very, because I want to, but I won't take any substantial amount of time at all. But I just want to read from the resolution itself, so Resolution L6/2022, the furthering of remedy and reparation for the aggression against Ukraine, which recognizes that the Russian Federation must be held to account for any violations of international law in or against Ukraine, including its aggression in violation of the Charter of the United Nations, as well as any violation of international humanitarian law, international human rights law, and that it must bear the legal consequences of all of its international wrongful acts, including making reparation for the injury, including any damage caused by such acts. So the resolution is really quite outstanding in a sense that it's very large, the mandate and the recognition that it provides to the violation of international law by Russia is really quite large, which makes it also, I think, quite interesting to note that so we had 94 votes in favor, but the 74 that maybe abstained, there were no one really challenged that part of the resolution, right? Maybe there were some other things, but so there's an incredible support. And what does it mean that you have a lot of support? It means that maybe creating this idea of the fund might be easy and easier, and the funds, as Mark-Jan was saying, will be replenished by possibly many different sources. It is possible that, as we've seen for the Iran-US Claims Tribunal, there might be later an agreement that is reached later in the game, so that Russia will voluntarily put funds in it, but there might be a need to compel those funds. And I think, Mark, you make an excellent point, saying that when you think about possible immunity and the frozen act, the frozen funds, they are in many different jurisdictions, and each different jurisdiction has its own rules on how to seize possibly these funds. Sorry, last thing, can I?
CLE credit UAL22, UAL22. Just very quickly, and then Jeremy.
Sorry, so your question was about peace and reconciliation. One thing is, just the idea that you have a claim commission as such, I think, will bring a long way to provide peace and reconciliation. And even the Eritrea-Ethiopia Claims Commission can be seen as a success in that sense, in that it stopped the war and there was some reconciliation there. Second thing, there is also a call now to establish a completely separate mechanism for the crime of aggression, and maybe there we will see certain acts of peace and reconciliation and historical record there too.
Thanks. Jeremy, do you have any thoughts?
Just to say, that's a fantastic question. It's actually one of the issues that the Columbia students are looking into precisely at this point, given its importance in modern claims commissions. And to that regard, I commend Ken Feinberg's book, Who Gets What, where he talks about this precise aspect. I'll leave it there.
Yeah, and I'll just take from Ken Feinberg to Grotius. I mean, one of the things that Grotius said, and this is one of Grotius's many points of genius, but one of the things that Grotius said in justifying reparations under international law was that reparations are necessary to ensure the future security of both parties to the conflict. Both parties, right? Reparations is a balm. It's a heal, BALM, not the other one. And I think that's important to maintain the future, not just rectify the harms of the past in honor of justice. So let me take us to conclusion. But before I do, I just wanted to say on a personal note, what Mark-Jan is doing is absolutely remarkable. He has been not with his family for many months. He's a credit to his country. He's a credit to all of us, really, as international lawyers. He is tireless. He lives on planes. He's doing this all for free, and he is always available, sometimes from bomb shelters. And he is just remarkable. And since this is the first time that we've appeared publicly since the resolution, I just think it's very important for me to thank him for what he's doing on behalf of us all. So now, before we go to coffee, let me just close by saying we're in your hands. We're in your hands, actually. You are the generation of lawyers now who needs to take up this mantle. For some of you, it will be the rest of your lives. For others, it will be most of your lives. And for very few in this room, it will be part of your lives. But the reality is, this is now our fight. And those of you in this room who are living at this moment have an opportunity to play an oversized role in stitching us back together. And we are incredibly grateful to be participating in this process with you, and very thankful to Benno and Edna for giving us this platform. Thank you very much.
Patrick and the entire panel here and far away, we are so grateful you could be with us today. It really is our honor, and thank you so much. You were terrific. We're going to break now for coffee and to speak to each other, and for 15 minutes. And then we will have our keynote, which we all consider to be very, very special. We'll hear from Jim Carter in 15 minutes. Thank you so much.
Yes, of course.
One of the highlights for Edna and me every year is to select the keynote speaker. And today we have someone who is a dear friend, someone whom we've worked with for many, many years, who's been frankly, not just been a friend, he's been a leader of the international arbitration practice in New York, in the United States, around the world. He's been a mentor for many, many lawyers who practice what we do here and around the world. And he's really been an example, frankly. He's been a statesman, an example of what we aspire to be. I know personally on many, many cases, the thing I always hoped for was that he'd be selected to be the chair of my tribunal, because I knew that with that came someone who had practiced many years as a litigator, as arbitration counsel, who had experience being chair and co-arbitrator in many, many, many cases, who was fair and who was smart, who had thought about many, many issues of international arbitration, written articles and chapters, spoken to groups like this here and around the world, and has undertaken leadership responsibility at the American Arbitration Association, at the London Court of International Arbitration, and at an institution near and dear to my heart, the New York International Arbitration Center. Jim has really been just an outstanding member of our community, and we are so honored to have him here today. He's going to speak, his keynote's going to be on arbitrator immunity and the limits of international harmonization. And Jim, it's just a pleasure to have you.
Thank you, Benno, for those kind words. It's a great pleasure to be a part of New York International Arbitration Week, highlighting New York's role as one of the leading centers throughout the world in international arbitration. So let me ask, for the start here, just a little bit of audience participation. How many of you serve or have served as an arbitrator from time to time? Okay, look around, that's quite a few. Now, for the younger of you, how many would like to? That's pretty good too. I think we've got the right topic for you, because I want to talk to you about something you have a personal interest in, arbitrator immunity. Picture this, you've been appointed as the sole arbitrator in an interesting, complicated arbitration. You've worked hard to do a good job. What could possibly go wrong? Well, throw this into the mix. One of the parties is clearly going to lose and knows it, and is represented by a very aggressive counsel who is going to do everything to frustrate the process along the way, to make your life difficult, to make enforcement of an award difficult, and maybe to try to intimidate you. Something along the lines of, well, if you do that, you're clearly headed into error. If you do that, my client takes these matters very seriously and has enormous resources and is determined to do everything it can to defend its position. And there you are as the arbitrator thinking about your award. What could go wrong? What personal liability might you have? Well, consider these potential bases of claims that somebody might make against an arbitrator. Gross negligence, for starters. You were not just wrong, you were really, really wrong in some procedural aspect that derailed an expensive process and had the consequences of requiring somebody to start over again at great expense, which somebody may be looking to get paid back. So an unhappy party claims gross negligence. What about a faulty disclosure? You made your disclosures as an arbitrator, but you left something important out. There's a case, Weisbach, that involved an arbitrator who disclosed that he knew, he was personally acquainted with one of the lawyers involved. What he didn't disclose was the lawyer's sister was his girlfriend. That was a bit of a problem and got the award in trouble, but suppose you willfully didn't disclose something. Now, in that case, one can imagine it wasn't an accident that he failed to disclose this rather significant fact. So you're charged with having willfully failed to disclose something that you, from your standpoint, quite innocently forgot to disclose. What about if you resign? Just the pressure of the lawyer that I've described makes it impossible, you think, for you to complete your mission, and you say, I resign. Well, or suppose the lawyer goes to court to try to get you thrown out in a country where he can do that while the arbitration's going on. Are you going to be stuck with court costs for the procedure that is brought against you? What about a false advertising claim? You make your disclosures, and it's on your website and so forth, but you say you're very experienced in this or that area of disputes, and it turns out that somebody challenges all of that, and this hypothetical lawyer that I've mentioned is going to be quick to claim that you've been engaging in false advertising, not being an arbitrator, but before you were appointed, you were falsely advertising your credentials. Are you going to get sued? How about something totally fabricated? Suppose an allegation is made that you took a bribe. Now, you know you didn't, but someone might say you did. Documents have been known to be created. There are cases, and there are cases raising each of these issues in the courts that have come along. And finally, what about just bad faith, whatever that might mean? Now, suppose a litigious former holder of high political office, for instance, who's angry over a loss in an arbitration, attacks you on his Twitter account, claims that you were biased and against him for improper reasons because you had strongly different political views, for instance. So he accuses you of acting in bad faith and sues you. Did something like that happen? It could. Now, these claims wouldn't get very far and wouldn't get much traction in an American court, but how much grief could they cause in the meantime? Consider the possible consequences of the mere assertion by a losing party of possible liability, civil liability for the arbitrator in a suit brought naming the arbitrator, and quite often then the arbitral institution as well. You get sued in a court, you're not going to recover your costs in an American court. You're going to have to bear the expenses of dealing with these claims, however frivolous you may think they are, and then the court may find they are. And most liability insurance that lawyers claim don't cover your role as an arbitrator. There is arbitrator insurance, but it's scarce and hard to obtain. Institutions, if they're sued along with you, may well support you and bear that cost, but you may be in a case where you don't have that asset. There's reputational harm, of course, just by being dragged into some sort of a lawsuit by an unhappy litigant. Ultimately, of course, there's an enormous chilling effect on what you're doing and on the process. So it seems to me that in our sprawling and diverse legal system, it makes concepts such as bad faith, or even gross negligence or willful misconduct all too easy to allege. The camel whose nose shouldn't be allowed under the tent edge. We don't have a place for that in our system of arbitral immunity. So let's look inside the tent of immunity. Here's my text and my thesis for my discussion today. The text. The United Kingdom Law Commission consultation paper came out a couple of months ago recommending various changes that might be made in the 1996 English Arbitration Act. And they addressed in one small chapter some aspects of arbitral immunity. And the report says, there is no international consensus on arbitral immunity. That we can agree on, I think, that is the case. So my thesis is that absence of an international consensus is, all things considered, not a problem. We do have a US consensus on how these matters should be addressed. US immunity law is sound and well-suited for our national needs, and an attempt to codify international uniformity at this stage in history would risk weakening that consensus and would be undesirable. Before exploring immunity a little further, let's ask, is there a problem here? Is there so much arbitrator misconduct going on that it requires civil liability to correct it? I think not. There are many remedies available for serious arbitrator error or misconduct. Starts, of course, with vacating the award. That's the main remedy that one has. Institutional discipline for an arbitrator who may not get appointed again if he's done something wrong. Possible forfeiture of fees. Reputational consequences, of course, for the arbitrator. In a serious case, perhaps even loss of one's legal license to practice. And ultimately, if there's criminal conduct involved, of course, there's no immunity for arbitrators involved in criminal conduct. What is the current status of immunity from suit internationally? Well, it's not covered by any international convention, at least as those have been interpreted so far, or by any international model law that has been enacted anywhere. Most national legal systems provide a zone of immunity for arbitrators, but with what to an American seems like fuzzy language when we come to discussing the exceptions. Gary Bourne's written that most legal systems provide no express statutory bases for civil claims against arbitrators, instead leaving such claims to be regulated under generally applicable principles of contract law. So, what is the framework for analysis of the arbitrator's obligation? How does contract law really figure into all of this? We hear that the arbitrator is a creature of contract, a creature. What kind of contract are we talking about here? There's, of course, the contract that the parties make, a bilateral contract to agree to arbitrate. Does the arbitrator become a party to that contract and as sort of an additional third party? Or is there conceptually a separate contract between the parties once they've agreed to arbitrate and the arbitrator, by which they engage him or her and choose the rules that will apply? Neither concept's entirely satisfactory logically for those who write about these things. If it's just an engagement, an enlargement of the bilateral arbitration agreement, what happens if that fails? What happens if the arbitrators decide that there never was a proper contract here? What happens to the contract with the arbitrator conceptually? Does she not get paid? How does that work out? And what kind of contract is it? Is it, in some civil law jurisdictions, there are important distinctions, I've been told. Is it a contract of agency? Well, an arbitrator doesn't exactly follow the directions of the principals who've appointed him under that concept. Or is it a contract for the provision of services? Well, you could see it that way, but that ignores the public adjudicatory function that the arbitrator is supposed to serve, which is outside the particular wishes of the party. The authors of Mustel and Boyd defined this some years ago as a legislatively conferred status, similar in origin to judicial status, but treating it totally outside the contract analysis. They wrote, with a little ingenuity, a contract between two persons could undoubtedly be devised. We suggest, however, that this would be a mistake. To proceed by finding a contract and then applying it to the ordinary principle, applying to it the ordinary principles of the law of contract will not produce a reliable answer unless a contract really exists to be found. We doubt whether a businessman would, if he stopped to think, concede that he was making a contract when appointing the arbitrator. Such an appointment is not like appointing an accountant, an architect, or a lawyer. Indeed, it's not like anything else at all. It's a separate status in their analysis. Just put aside the whole concept of contracts. Now, Bourne would see it slightly differently. He says if we are drawn logically to some type of contractual analysis, then we need to say right out that it's just a sui generis type of contract based on a specialized and distinct mandate to fulfill an adjudicatory function. And he cites what one court's written about this. It doesn't seem permissible to treat the arbitrator as the equivalent of a representative or an employee or an entrepreneur. His office has an entirely special character, which distinguishes him from other purposes in handling the affairs of the parties. He has to decide a legal dispute in the same way as and instead of a judge, identifying the law by matching the relevant facts to the relevant legal provisions. The performance expected from him is the award, which constitutes the goal and outcome of his activities. It's true that the extent of his powers depends on the arbitration agreement, which can, to a greater or lesser extent, prescribe the way to that goal for him. But apart from this restriction, his position is entirely free, freer than that of an ordinary judge. That was written by the German Reichsgericht in 1904. Nothing's changed much since then. So there's a tension between contract analysis and this status approach, with theorists trying to seek some kind of balance, saying, yes, there's a special status that entitles the arbitrator to immunity, but a creature of contract. And so there may be some obligations here that carry the type of consequence that we normally think of when a contract is breached, which of course could include civil liability. So how do we straddle all of that and make some sense of it? Well, let's go back and look at judicial immunity, because that's what we're talking about here as a start. We're talking about quasi-judicial immunity, so what about judicial immunity in the US? The same type of problem here, this conceptual problem of creature of contract, arose 150 years ago in the case of judges, resulting in the rule of absolute arbitrator immunity based on absolute, although it's not really totally absolute, judicial immunity with a functional focus. A little history. John Surratt was involved in a trial because when a number of the alleged conspirators with John Wilkes Booth, including Mr. Surratt's better-known mother, Mary Surratt, were arrested, tried, and executed after President Lincoln's assassination, John Surratt was sought but escaped. He got to Canada and eventually to Europe. He was apprehended and extradited and eventually put on trial in Washington before the Criminal Court of the District of Columbia in 1867. He was defended by an attorney, Joseph Bradley. Now, John Surratt's trial, incidentally, resulted in a hung jury, apparently because some jurors accepted his defense that he'd conspired indeed in an attempt to kidnap President Lincoln, but was not part of the conspiracy that was actually being charged, which was to assassinate the president. But during the course of that trial, Surratt's attorney, Bradley, allegedly accosted the trial judge, George Fisher, as the judge descended the bench one day. Well, he accosted him verbally. He didn't raise fisticuffs with him, but he called him some name, which the Supreme Court decision does not report for us. But the decision does say that it was delivered in a rude and insulting manner. So, following conclusion of the trial, Judge Fisher, on his own initiative and without any kind of hearing, effectively disbarred Attorney Bradley by striking his name from the attorney roll of the Supreme Court of the District of Columbia. That summary decision eventually was set aside, but in the meantime, Attorney Bradley lost income and he sued Judge Fisher for damages. The result was the U.S. Supreme Court's 1872 decision in Bradley against Fisher. Justice Field, writing for the court majority, affirmed dismissal of the case, and in fact, this had been an improper action and he couldn't be stricken from the rolls and because this judge didn't have jurisdiction over that particular function. But the opinion went on to state that allegations that Judge Fisher had acted maliciously or with a corrupt motive were insufficient as a basis for damages claimed against him because the judge enjoyed immunity from such claims. Applying the common law, the opinion proclaimed as a general principle of the highest importance to the proper administration of justice that a judicial officer exercising the authority vested in him shall be free to act upon his own convictions without apprehension of personal consequences to himself. And the court pointed out that this immunity easily could be defeated if there were an exception for allegations of corrupt motive, since such accusations could be made by losing parties in many situations, indeed, in my hypothetical situations. In addition, the court stated that aggrieved litigants had a primary remedy for judicial error or misconduct in the form of an appeal asking for a reviewing court to reverse or an improper decision. And then the court said, be it malicious or otherwise. That is your remedy, not a private suit. Now, the opinion noted the availability of exceptions, and these have become part of our law of judicial immunity as well. One is for total absence of jurisdiction for non-judicial actions, so the immunity is absolute only within those limits. And the court found that while Judge Fisher had jurisdiction to sanction an attorney appearing before him for misconduct, he erred in not giving the attorney, Bradley, an opportunity to show cause why a sanction wasn't necessary by way of explanation or defense. But this erroneous manner in which its jurisdiction was exercised, the court continued, however it may have affected the validity of the act, did not make the act any less a judicial act, nor did it render Judge Fisher liable to answer in damages. For if at the suit of the plaintiff, as though the court had proceeded without having any jurisdiction whatever over its attorneys. That wasn't the only word here. There was a dissent. Justice Davis, on behalf of himself and one other justice, expressed what echoes today as a contrary view. The dissent maintained that where it is alleged not only that his proceeding was in excess of jurisdiction, but that he acted maliciously and corruptly, a judge should be subject to the suit the same as a private person would be under the circumstances. So there's the echo of this creature of contract. Why should a judge be treated differently from others if he's acting maliciously and corruptly? Well, the answer is he still is. That's what the Supreme Court said, and that's what our judicial immunity law has continued to include. If a judge is acting in a judicial capacity and is not taken in actions are not taken in the complete absence of jurisdiction and don't involve, there's another exception for an administrative capacity, hiring employees, for instance, then the immunity is absolute. For instance, one of the cases is typically cited where a judge is off the reservation entirely and not acting within jurisdiction is the famous case of the coffee vendor who was, the judge sent his clerk out each day to get coffee from this vendor, and it was bad coffee. And he got so mad that he told the clerk, go out and put handcuffs on that man and bring him in here. And he did, and the judge expressed his views about the bad coffee. which was outside jurisdiction. So that we can agree on. So the rule of judicial immunity was extended to quasi-judicial officials in the case of Butts against Economou by the Supreme Court in 1978. So arbitrators acting in their quasi-judicial arbitral capacity are immune from civil liability, using Justice Field's words, be their conduct malicious or otherwise. That's US law. And of course, there are parallels to the exceptions in the case of arbitrator immunity. You can again think of sort of the total absence of jurisdiction. When is the arbitrator doing something that's not part of being an arbitrator? And one of the cases that raised that issue was a New Jersey case, Malik against Ruttenberg, where a New Jersey attorney representing Mr. Malik, who was a contractor who'd agreed to perform some renovations in someone's home, objected to the activities of one of the attorneys on the other side for the homeowners during an arbitration, and asked the arbitrator to remove the attorney from the other side from the proceeding based on whatever it was he'd said or done. And the arbitrator denied that request, and things were becoming a little heated, so he declared a recess quite sensibly here to let things cool down. And during the recess, according to Mr. Malik afterwards, the homeowner's lawyer, whom Mr. Malik's attorney had sought to eject from the proceedings, retaliated by physically assaulting the beleaguered contractor, Mr. Malik, in the lobby of the building. Mr. Malik, these things really happen. Mr. Malik then sued the arbitrator, who wasn't even present at the altercation in the lobby, and the AAA, claiming that they both knew of the dangerous propensities of the homeowner's attorney, but failed to exercise reasonable care to control these tendencies. Well, that proved unsuccessful because of arbitral immunity, but what if the arbitrator had intervened in the fight? Would that have been acting outside his jurisdiction? What if it happened out in the parking lot and not in a recess of the hearing? You can imagine a situation where an arbitrator also would be acting outside his jurisdiction. So of course there's an exception. There also was an exception for a sham arbitration situation in the wagon blast case in Minnesota in 2010. The allegations there were that members of a law firm conducted sham arbitrations on behalf of bank credit card customers to try to establish lack of liability on credit card debts by rubber stamping no liability. And the authorities got after them, and that was held to not be an arbitration at all. So you can see how the exceptions that were devised for judicial immunity have been adapted and applied by judges to arbitrators' conduct. But fundamentally, then, it comes down to what is acting in an arbitral capacity when the examples are more challenging. What is the arbitrator's function? Does it extend, for instance, to failure to act at all, such as a failure to disclose a conflict or just a failure to complete the award within the time that's been specified by the rules? You didn't do anything other than just drop the ball, fail to act. Is that somehow an exception? There are some cases that also speak in terms of decisional acts. An arbitrator is immune if what he or she is doing is part of a decisional act. Well, okay, writing an award, decisional act. Making your disclosures before you're appointed, is that a decisional act? Well, if a decision really includes everything that's involved in being an arbitrator up to the point of making the decision, I suppose so, but that seems a strange limitation to put on it. The focus for a judge is whether it's within the concept of judicial activities. And so most courts have taken that approach with an arbitrator too, asking whether he or she is acting in a quasi-judicial capacity, which can include, of course, disclosures. Judges have to make disclosures too. When a judge thinks about these exceptions, the mind naturally runs to what the court system encounters in a similar situation, such as disclosures. And judges tend to say, well, that's something I understand to be part of the process of an official doing this, and a quasi-official actor should be treated the same. Courts sometimes also look to see whether the attack on the arbitrator can easily be categorized as a collateral attack on the award, and look right through all of this analysis and say, this is really an attempt just to get out of the award by blaming the arbitrator rather than blaming the result. And we're not going to have that. So that's kind of a shorthand approach to dealing with all this. Now, modern statutory trends, I submit, go beyond the common law and establish the right to immunity using this judicially based language rather than contract language, and that's a good thing. The gold standard is the revised Uniform Arbitration Act in 2000, which simply says an arbitrator or an arbitration organization acting in that capacity is immune from civil liability to the same extent as a judge of a court of the state acting in a judicial capacity. So that's the statutory law in about half the states of the country. No except, but, gross negligence, malfeasance, bad faith. It just flat is the same extent as a judge acting in a judicial capacity. And that was accepted as general American law by the restatement of the law of U.S. international, commercial, and investment arbitration, which says, quote, international arbitrators are, to the same extent as judges, immune from civil liability for acts or omissions within the scope of their duties, period. None of these little exceptions creeping under the edge of the tent to give comfort to that aggressive lawyer that I described at the outset. Now compare the experience in the United Kingdom. The law before the 1996 English Act was simply the common law. There was no statutory reference to judicial, or rather to arbitrator immunity. And it was based largely on contract law principles. And so when we got the Arbitration Act in 1996, it says, an arbitrator is not liable for anything done or omitted in the discharge or purported discharge of his, and they would now say her, functions as arbitrator unless the act or omission is shown to have been in bad faith. There's that word. Now, the English seem to be comfortable with knowing what bad faith is, but my aggressive party here in the US might well have a different definition for it. There are judicially created exceptions still in the United Kingdom, and one of them is if the arbitrator resigns, and by a strange line of authority, strange to American eyes anyway, this is seen as a breach of a contractual obligation to complete the mandate, and the arbitrator can be charged with the costs. If somebody then charges him with improperly resigning without good reason, without agreement of the parties, he may be charged with the costs of the court case that establishes that. And indeed, the commission says, hard to believe, this line of authority says that the arbitrator can be charged with the court costs, even if he prevails and establishes in court that he had a good reason to resign. So the Law Commission in its report this year has suggested a possible fix to clean that up and disavow that line of authority. But it shows, to my mind, the difficulties that follow if you do something other than provide clearly and cleanly that quasi-judicial immunity follows judicial immunity. There's a little bit of outlier US case law that suggests that this creeping nose of contractual analysis has still a role in some cases, generally not followed in the US. But the restatement in its reporter's notes, not in the statement of what the law is, says, despite general agreement about absolute arbitrator immunity, a minority of courts and several commentators have suggested that it might be inappropriate in certain contexts. Under this view, arbitrators perform quasi-judicial functions, but they are also, here's this phrase, creatures of contract, paid by the parties to perform a duty, and their decision binds the parties because they make a specific private decision to be bound. And then they go on to say, in light of these differences, at least some courts have reasoned that US law should be more consistent with the standards in foreign courts, which permit liability when arbitrator misconduct is so extreme that any arbitral outcome is not part of a legitimate deliberative process. Now, in fact, I've not found any court in the US that says, I see a foreign law that makes more sense, and that's what our law really ought to be like. That's not generally what US courts do, and there's none that's done it in any of these outlier cases. But, the note continues, many scholars, many, have argued for courts to acknowledge exceptions to arbitral immunity for bad faith and egregious misconduct. And the note cites 3 articles for these many scholars. Now, in my view, that's not the thinking of right-minded legal commentators. No US court has actually said that we ought to be following this example of making exceptions for malicious or allegedly malicious conduct. And the thinking ignores US statutory law and the analysis of our courts, going back to Bradley against Fisher. So the note does end in this grudging conclusion. To date, however, these proposed exceptions to arbitral immunity are not generally recognized under US law, where immunity remains absolute. Good, I say. So, 2 cheers for harmonization. We've seen an era of harmonization in international arbitration that's done enormous good, beginning perhaps with the IBA rules of evidence, other efforts to combine civil and common law traditions to devise model statutes, models of all kinds that are a good thing. And occasionally, we now see suggestions that there ought to be something of this kind dealing with arbitral immunity. We know from our starting thesis that there is no consensus about all of this. And so the natural tendency is to try to make one by combining the various concepts that are out there. And I think that's a bad idea at this point in time. Only 2 cheers for harmonization, not 3. There's no sign of rampant arbitrator misconduct requiring civil liability or requiring exceptions. There's occasional US judicial confusion over this contractual model, but there's hope for us in sticking to the judicial immunity model, most of all because judges understand it and they can apply it conceptually when an issue arises involving an arbitrator or an arbitral institution. So, and that's important to protect arbitral independence and decision-making. To go back to the very beginning, why do we have this rule for judges? The same reason that we have it for arbitrators, so that one can proceed with the view that at least that threatened sanction against you of civil liability is not going to stand. So let me leave you with the words summing this up of the late arbitrator and scholar Martin Hunter, who once wrote, "Arbitrators may act with impunity, for theirs is a favored community. Though losers may whine and even malign, judges will guard your immunity." Thank you.
Jim, thank you so much. It was such a pleasure to have you here and to hear you regale us on a topic that's dear to our hearts and for which the Second Circuit and the courts in New York have been right on key consistently. We will break now for lunch. We will resume with our second panel at 1:30, pretty much on schedule. Lunch is to my left, to your right. And we look forward to seeing you in an hour. Thank you so much.
Okay, well, welcome for the afternoon session. Thank you so much for staying through. I know it can be a long week. So, every year when we do the Fordham Conference, we like to have one session that's inspirational, as we had this morning, and one session that's more practical, like things we should really be thinking about as we practice as arbitrators. And so I tend to do the practical one and Benno does the inspiration. It seems to be a pretty good division of labor between the 2 of us. So I like to think that being practical can also be inspirational, and we would like to inspire very good practice among arbitrators. So as we thought about what we could do that's practical this year, there was nothing like new on the horizon. Lots of new rules, but emergency arbitrators have been around, expedited has been around. The CIAM hasn't come up with some new guidelines, so what are we going to do? So we thought actually what would be best to do is to follow on from what we presented last year. So if you'll recall, if you were here, our presentation last year for the practical side was about the mixed mode project, which was launched and completed just about exactly a year ago and launched at this conference. And the subgroup that I was responsible for really had to do with things that arbitrators can do, staying within their role as arbitrators, that can be techniques that might assist the parties to get to settlement. And we chose techniques that were well-established, well-known, created no issues with respect to whether or not the arbitrator had the authority. And I think we did a very nice job of that. And we thought, how do we take that forward this year? And we thought, actually, what would be most interesting is to come up with some sort of new, novel, interesting additional steps, but also to really talk in a broader sense about engaging with the parties. I think we've all been at too many first case management conferences where excellent chairs of great renown, very competent, have really done no discussion with the parties of the case essentially at all. It really is just essentially a scheduling conference and a sign off on the PO1 that was sent in advance with maybe one or two little tweaks, and just no discussion with the parties about that particular case, what's unique about it, how to frame the issues, what the process should be that's really tailored to the case. So what we would like to talk about is engaging with the parties more and some specific tools that would help perhaps in some cases to get the parties to settlement and would also and contribute to efficiency and cost saving, which we always care about. So it's a little bit of a potpourri addressing both of those kinds of suggestions for your consideration. We have a really excellent panel, as we did this morning, but this is a panel with a different kind of expertise and really perfect for today's session on this subject. So in alphabetical order, Chiara Bao at the far end, has just served on an almost completed and soon to be released task force on ADR arbitration that the ICC has been conducting for the last 2 to 3 years. I know Jan is also on that. I was on the advisory council for that project. It was a huge project that engaged many, many, many people all over the world, including in-house counsel, with whom there were many sessions, again, all over the world. So it's a very richly contributed to effort, and Chan was the chair of that. So I think really a perfect person for the session. She's also vice president of the ICC Court of Arbitration, vice chair of the IBA Arbitration Committee, and she also served from 2010 to 2018 as the Secretary General of the Hong Kong International Arbitration Center. So very much in the thick of the kind of things we're going to be talking about. Dominique Brown-Bourset has acted in over 250 international cases around the world. She has served as the co-chair of the Arbitration Committee of the International Bar Association. She is the vice president of the Chartered Institute of Arbitrators. She served, importantly, as one of the first presidents of Arbitral Women, and as a member of the LCI Court of Arbitration. And she has a particular interest, as it says in the program, in dispute and negotiated settlement tools related to arbitration. David Rifkin, who is the second from the left, is a partner at Debevoise with more than 40 years of experience in arbitration and served for many years as co-chair of the firm's International Dispute Resolution program. He's a former president of the International Bar Association, and again, of particular relevance to the subject of today. He published a paper way back in 2008 when people were really not talking about this, called the Town Elder Paradigm, which he has now actually turned into a set of protocols. And you can all remember what a town elder was all about, right? Helping people resolve disputes, making a decision for them as to how to resolve a dispute. And he goes way back on the subject. And finally, Jan Schaefer, who is in Frankfurt. He is the head of the German dispute resolution practice at King & Spalding. He's a delegate to the ICC Commission on Arbitration and ADR, and a board member of the German Institute of Arbitration, the Arbitration Institute of the SCC, and the Dutch Arbitration Association. And I met Jan many years ago, and he was kind enough to write a really excellent article for our New York State Bar Association publication about some of the German techniques that you will hear a little bit more about as we progress. So with that, we have a little agenda, and everybody is going to speak about something, and we will have audience participation, I think, a little bit later in the program. So Chan, she's going to start, before we get to actual disputes, based on the experience that was had with, as I said, they had open mic sessions with corporate people all over the world as part of the ICC effort. And so before we get to disputes, we're going to get to what people really want, if on the business side. Chan?
Thank you very much, Edna. It's a pleasure to be here, and to Fordham for inviting me. I think one of the innovative aspects of what we're
Can you hear, is the mic working?
No. Yeah.
Is it
Turn it on. That might help. One of the innovative aspects of our program today is, in fact, that dispute avoidance actually features in our conversation about dispute resolution and alternative dispute resolution. Obviously, dispute avoidance is before the dispute resolution process happens. And in fact, one of the key areas that this task force focused on, and indeed the users or the businesses really focused on, in particular in the time of the pandemic and post-pandemic, was avoiding disputes. We can call it conflict management, we can call it dispute avoidance, whatever you want to call it. It is before the moment of this dispute taking fruit and becoming an issue or a dispute that a third party neutral needs to engage with. And so the reality of what we're talking about today in terms of dispute resolution really has to start at the outset, when the contract is being drafted, and good contracting is a key aspect of the dispute avoidance process, as well as communication. Building good communication, relationships, et cetera, right at the outset of the contracting stage or phase is something that companies and businesses were particularly keen to not only appreciate the importance of, but really request from counsel, outside counsel, and even arbitral institutions as to how to really engage at the outset in contracting phase, drafting contracts, drafting the arbitration clause, and ultimately building rapport, building a relationship with their counterparties so as to avoid disputes. Certainly, many statistics have indicated and supported this need, but in particular, part of the reason why we raise this as a bullet point in our discussion today is, in fact, because companies and businesses demand it and want it, not only of themselves, their internal clients want it, but their external counsel must be able to engage with them at the outset. And so this now changes the dynamics, I think, between the relationship between within law firms, between their corporate lawyers as well as dispute resolution lawyers. Obviously, in big international firms, there is constant and fluid communication between these two types of lawyers. But in smaller companies, and when when we're reckoning with small and medium-sized enterprises, there isn't that level of sophistication. And so the importance of what we're talking about today is to put focus and highlight the importance of avoiding disputes and getting all parties, including external counsel, corporate counsel, to have these conversations before the dispute actually arises.
Dominique, did you want to add something?
I just want to add that when the process described by Chan is followed and discussions are unsuccessful, as is sometimes happens, the arbitration that is going to follow may start on a slightly different footing, because the parties may already have expressed their sensitivity to a possible settlement, and dispute avoidance, it's too late when you are in the arbitration, but dispute settlement is not too late, certainly. And this is probably what we're going to discuss.
I just want to add that I had one experience last year that kind of fits right into this. So I think many of you are familiar with dispute boards, where there is, standing neutrals to deal with construction projects, but it really doesn't get used much at all, if at all, in other contexts. And I had one case at the beginning of the pandemic, and it was a company that had developed antibody testing procedures and had a distribution system already set up through a distributor. And it came in with appoint 2 arbitrators, they appoint a 3rd, but the contract specifically said that we should meet with them for, once a week for the first 2 months to get to know the business and to help them through any issues that arose. So it really was essentially a DRB set up in the context of a straight commercial relationship. And I think the real contribution that we could all make to this field is to have more of that happen in any kind of long-term relationship, whether it's a collaboration agreement, a purchase and sale agreement with, a long-term of supply, joint venture. There's so many contexts where there are long-term commitments, and it just doesn't get done. So I think, that's kind of, to me, the next step of a new process that really could be used a lot more to serve the dispute avoidance preference of all the businesses. Obviously, they'd much rather avoid the dispute. So my contribution to hopefully what will be coming in the future. So Dominique, you want to talk a little bit about establishing a relationship with the parties at the beginning?
Yes, Edna, thank you. Firstly, I would like to say how delighted I am to be with you in New York after all this long time without coming. It's great. The key word for me in international arbitration, for it to be successful, is communication. It is essential that communication is established between the arbitrators themselves first, so that they know if they are on the same line about the approach they would like to follow or not, between the arbitral tribunal and the parties and counsel from the outset, and between the tribunal and the arbitral institution, as in some cases the rules do not quite fit the situation, and the tribunal should step in and get in touch with the institution to see how things could be adapted. What is essential is, of course, to have the parties present at the beginning, at the first case management between the arbitrators and counsel and the parties, and to have them involved in most of the management of the case even later on, if possible. This, of course, requires the parties' agreement. Some of them are not keen on being so active and present. They prefer to be behind outside counsel for all sorts of political reasons internal to their firm. But more and more, we see that outside counsel and even decision makers agree to come to the table, meet with the arbitrators, which is very important for us because it's nice to put a face on, so to speak, the company and the parties and have a feel for the sort of dispute which is going on. And also they are keen to be there because they know, or they start to know, that a number of arbitrators are ready to be quite open and address issues which are not in the written rules. They go beyond just the procedural order number 1 that everybody knows and this discussion of the procedural schedule. They try to plant the seed of a process which perhaps can create a cooperative dialogue between all the actors in the arbitration that will help ultimately either the parties themselves to find that perhaps on balance, it is still better to enter into some form of amicable solution with or without the help of the arbitrators, or that they want to go all the way to the end, in which case the cooperative approach and the tools which can be used that we're going to discuss in our subsequent discussion could also help the arbitrators to make and to reach a sound solution. And the goal is often to evacuate all the issues which are not ultimately relevant to the resolution of the case at the outset of the proceedings. So the start of the dialogue at the beginning is absolutely crucial to succeed. There are several ways of doing so. They are usually not addressed in the rules, except in the German rules of the DIS. at Article 27, if you choose these rules, you will have a lot of options to opt out if you don't want to have a preliminary assessment of the case by the arbitrators, which is otherwise automatically done. So that could be interesting. In the other rules, it's not the same. And also, what is very important at the very start is for the parties and the arbitrator to discuss if they are open to some sort of settlement or approach, and how they want, if they want the arbitrators to be involved, and if so, how. And I think that we're going to discuss how this is done, especially more often in certain countries than in others, where there is a tradition of conciliation also in court proceedings. So the key word for me is communication, exchanges, communication, because the setting of an international arbitration is almost a disaster, a recipe for disaster. You have 3 people coming from 3 different countries in the arbitral tribunal, speaking different languages, different legal background. You have parties as different as the arbitrators, if not more, and they sit often in a country which is not the country. Everybody speaks in English, which is the lingua franca of arbitration now, but not everybody understands the English term used by each arbitrator or each counsel in the same way. So it is essential to communicate throughout the proceeding until the end.
John, did you want to add something? It's just a couple of points. Certainly communication is key, and this is what Dominique has impressed upon us in her commentary. A couple of points in relation to virtual engagement, and certainly the pandemic has taught us that it is easy and there are no barriers really to have as much communication as appropriate for any given case, and in particular in the outset of the arbitration. And so there should be no excuse in not only engaging at all, but also with, as Dominique had indicated, with getting the companies and the businesses to the table. Another aspect to raise is as well in relation to the open-ended number of questions, or the questionnaires. Certainly I'm sitting with Edna in the past. I know that she has a nice extensive list of questions that she asks the parties, which I find to be very interesting and frankly refreshing to have the more open-ended questions than more directive questions that I traditionally see. And so taking a page from her book, having these types of questions that do ask, do you want the tribunal to be engaging in settlement or making that effort, and all of these other aspects to the process that one might not see in the course of dealing with a template PO1 at the outset of an arbitration, I think is very refreshing. I also wanted to mention about nonverbal communication. Obviously, communication comes in many forms, and nonverbal communication was never so highlighted in my practice until we had 3 years of not having in-person engagement, and then suddenly my very first in-person arbitration post-pandemic, or after this long hiatus, really made me appreciate all the reading of the room and how to see from your periphery as to what the counterparty is doing when the primary party is speaking, and what your co-arbitrators are thinking. And all of these aspects of the nonverbal communication I find to be just as important as what's actually being said. And so those are kind of a few feedback points on the importance of communication.
Absolutely. David, I know you had some thoughts about having the parties available and present during those early meetings so that they have some input into how the process is conducted.
Yeah, I think, we have to be careful when we say the parties, because sometimes when people talk about the parties, they're including counsel in that. But I think all of us here, when we're talking about the parties, we mean the parties. And it is very important, I think, to have the parties, in-house counsel or an appropriate business person at the initial hearing, and frankly at every hearing with the arbitrators. I've had a good number of experiences where outside counsel have come with certain ideas about how the case ought to be handled. But then as arbitrator, the tribunal was able to say to the parties, do you really want it done that way? You're in a difficult joint venture right now. Can you really wait 18 months for the hearing? Wouldn't you rather have the hearing in 9 months? Wouldn't you rather have some contract interpretation issues decided right away to help you in the joint venture? And of course, then the parties go, oh yeah, I didn't know we could do that. And so I think being able for the tribunal to talk directly to the parties whose interests may not always be the same as their outside counsel is vitally important.
Yeah. Oh, I forgot to do the CLE is C as in cat, A as in apple, P as in Peter, 22, cap 22. So I am curious, raise your hand if you have been in a first case management conference, first preliminary hearing with somebody else's chair, where it's basically just been a scheduling conference and really no real discussion of what the case was about and how it should be handled. So raise your hand if you've had that experience.
Yeah, me too.
Not surprising. Okay, many, as have I. And I guess the converse, how many of you have been involved in a case management first preliminary hearing with somebody else chairing who did really engage the parties and really did have a serious discussion about how the process should be structured in that particular case, what kind of steps should be taken? How many have had that experience? Many, many fewer. So we have a long way to go. And that is actually going to be one of our final questions. How do we move the needle? I know I was talking to a practitioner who is very, very committed to mediation windows. And she said she has, that to me just seems like such an innocuous no-brainer to bring it up as a possibility at the first conference. And she has a horrible time getting her co-arbitrators to even agree to bringing it up as a possibility to suggest to the parties. So I think, there is a long way to go, both in terms of parties and in terms of the arbitrators. Okay, so next we have David up to talk about some, we said some of the stuff we would be suggesting as sort of cost-cutting tools that you may not have thought of that really might make the process a little more expeditious and a little less costly. David?
Sure. Thank you, Edna. So document production, we know, is a time-consuming process within every arbitration and often one that contributes very substantially to the costs. And remarkably, we still make the requests for documents, even in compliance with the IBA rules. We always make those requests in the same form, in the same manner that we did when I was a young associate 40 years ago. And the way you search for documents was by going to a client's offices and looking through their paper files. And then the request made us whose files they were and what file folder that a relevant document might be in, and you can go to that. But we all know that once you receive the document request from the other side, that's not what you do anymore. What you do is you think about the search terms that you might use in order to find the appropriate documents and who the appropriate custodians are. So it'd be far better, it seems to me, for the parties to engage in this through an iterative process. And instead of making a document request in the form we're used to, documents relating to this or, your document sufficient, whatever it would be, to often simply give search terms that you think are going to be relevant, that are going to find the documents that you want. And to the extent you can, identify proper custodians, because you've already, if there's been a regular business communication, you probably already know a lot of the major players on the other side who would be there. And then to engage in that process and to work with the other side in saying, no, this search term is going to turn up too much, whatever. You can do a first cut at that. Again, this would work for both sides. Each side does a first cut with whatever has been agreed at the beginning or requested at the beginning. And, lo and behold, it turns up 2 million documents. So then you go back and you say, all right, you talk to each other and say, okay, so what's causing the 2 million documents? How do we actually reduce this to the meaningful collection of documents that might actually provide documents that are relevant and material to the arbitration itself. And I think, again, the new virtual tools that we've developed can make this back and forth much easier to do. It is in both sides' interest to engage in an iterative process like this because it could ultimately save their clients a lot of time and money. And it's at least as likely to come up with documents that are going to be useful in the arbitration and turn up as evidence. Sure, it might miss some documents, but the current process misses some documents too that could have been important. So I think this is something that counsel and arbitrators ought to consider more, to experiment with. And Edna, I know you mentioned that you've actually done it in one case, and it was came across quite usefully.
When you think about all the hours you spend looking at the Redfern or Stern schedule or the parallel letters, which are such a pain in the neck to read. So I had one of those and it was going to be very difficult to sort through. So we said, why don't you see if you can agree on search terms and custodians? Well, that was it. That was the end of the problem. So, you really might want to consider that in some cases because it's very effective. Jan, did you want to add something?
Yeah, I just wonder at what point in time you do that, because don't you need the decision by the arbitrators on principle that you have to disclose something and then you can engage in that iterative process? Or is it like, okay, everybody assumes we have to give something out, so then we start from that assumption? Because if you look at the civil law world, we are very adverse to document discovery, because that's not part of our litigation understanding. I think the arbitration lawyer now understand that that's part of international arbitration practice, but still they're not really used of how to do it. And in particular, these days, when you look at electronic documents, and you just, the arbitrator says, okay, that's the categories you have to hand out, and you don't know who are the custodians and how you can narrow this. It's really, really time consuming, very costly, and it gives a negative impression on arbitration. They say, why do we spend all that money for what? But for me, the question is, when is the point in time that you would engage in your iterative process?
I think you could do it either way. You could either begin with just each side proposing search terms relating to certain issues in the case to each other. If one side thought that that issue was irrelevant or the search terms were unnecessary, you could always take that to the arbitrators in the same way that we take other issues. Or you could have something, some general discussion of the types of documents you're looking for, and then start talking about it. But it's always interesting to me when people talk about the IBA rules of evidence and say that was kind of a common law takeover of arbitration. We had, I think, about 18 members of the committee that drafted them. 3 of us were common lawyers. The rest were all civil lawyers. And it really began by building out, from what was even common in civil law, which was where you could ask for a particular document. And then if you knew there was a board meeting, but you didn't know the exact date, but you knew that there must have been a decision to terminate this joint venture at some point, you could say, well, documents relating to the decision, that even that would fit within a civil law framework, even though you weren't identifying. And then that's how we came up with the formulation in the IBA rules. So it is there, but it's no doubt it's a problem for parties from common law, civil law, all jurisdictions right now. It costs too much, it's bad for arbitration, and we need to find ways to simplify the document production process.
Yes, it does highlight, I think all of us are guided a little bit by our original legal culture, even if we do international. So we tend to be colored a little bit by, common law versus civil law predilections, shall we call them. Anyways.
Can I just add one thing? It's very interesting discussion between a common law lawyer and a civil law background lawyer, which is quite typical. And here again, the issue of communication is key, because the arbitrators have to explain to the civil law background parties and counsel that even though a party doesn't have the burden of proof, this party may be asked to produce documents, which in our system is almost a heresy. We don't do that. In arbitration, this is done. There is a process which has been developed and is accepted, but one shouldn't assume that it is clear for everybody and that everybody understands it in the same way. And very often, a lot of the procedural disputes relate to document production, in particular, as David said, because of the costs involved. and the fact that there's unequal power between certain parties. Some have access to the latest IT tools, some don't, and poor arbitrators often don't have any artificial intelligence or IT tool to help them with the boxes and boxes of documents or the number of USB keys they receive. So this is really a very acute problem, which David is proposing an interesting solution, and maybe it can be a little bit adapted to be used more easily by the non-Anglo-Saxon lawyers who don't have experience of international arbitration.
Interesting. Okay, Jan, you're on next for a little bit more about CMCs and some of the interesting ideas you have for the first case management conference, first preliminary hearing.
Yeah, thanks, Edna. I think the beauty of arbitration is the flexibility. And so we can have bespoke solutions, but to have something bespoke, you need to speak and you need to talk. And that means that you really have to engage. And that ties in with the first topic to say, well, you need to be able to speak. And I think at most of the times when we have the first case management conference, that is, you have the request for arbitration, often the claimant leaves it very open so that they have still a lot of room to maneuver. And the respondent, they have a very tight schedule to put in their answer, so they often leave it open as well. So basically what you end up with as an arbitrator as the first case management conference is very, very preliminary pleadings. And the case develops. And is that the right point? And that's what I question. Is that the right point to really make fundamental decisions on the arbitration? What you can do at the first case management conference is a kind of a kick-off for the projects. You get the people to see them, you see the actors, the arbitrators can get together, you can organize a lot of generic rules. What are the deadlines to meet? What are the formatting requirements for your submissions? Do you need to put in witness statements with your submissions, expert reports, and so forth? But what I think is very difficult at that early stage of a case to really make an informed debate about what is best for the case, how to structure it, and how to put on the timelines. So what you often see is like, okay, when do we find a common date for the hearing? And once that's fixed, maybe 2 years down the line, then you work backwards and say, okay, what kind of stuff do we put in between? And then you normally come up with just a normal way of doing it. 2 rounds of submissions. In between, you have your document discovery phase, and then you have your pre-hearing conference call, and you have your day in court. But that's basically pretty much standard, and it's very standardized. And I think my proposition would be to say, the first case management conference is just a kickoff, get to know each other, set the ground rules for the next submissions, then have the statement of claim in, the statement of defense, or the reply, the statement of defense, and then meet again. And that will be the main case management conference, where you identify the issues in disputes, where you think about how do we structure that? Are there certain issues that can be fast-tracked? Are there certain issues that are more helpful for the parties to get resolved quickly, as you mentioned with the contractual claim, for instance? But that really requires that the arbitrators, if they can be of help to the parties, and even the parties themselves, because often the parties and the counsel don't know the case properly at the first case management conference as we see it today, that you then engage again in an informed discussion on the basis of the statement of claim and statement of defense on how best to structure the arbitration. Of course, that means that you can fix the hearing dates later down the line, maybe 6 months, 8 months later than today. But I think that shouldn't be a reason to say that we just want to autopilot everything in the beginning. And once you set the timetable and you have the hearing date, everybody says, well, we cannot do this, we cannot do that, because we want to maintain the hearing dates, because it will be so difficult to find new dates. And then people say, oh, we need long deadlines for our submissions because we don't know what will come up. And we need to have room to maneuver. Then you need to build in buffers. And then you end up with extremely lengthy arbitration proceedings that just follow a similar pattern. But it's not measure-made, it's not bespoken. So what we basically do by being so early with our case management conference, we give away a lot of the beauties of arbitration and the flexibilities. So my proposition would be have your first case management conference as we do it now, really early on, but then pause, have your first round of submissions, take the time, the tribunal to look at them, take the time, the parties also to think about where do we stand now and what is the appropriate way of going forward, and then discuss the hearing, the entire timetabling up to the hearing. And that will be, I think, a much more efficient way of doing it. You can have different tracks, you have maybe shorter deadlines because you know what's critical, and you will be able to identify the true issues in dispute and really work them out. That would be my proposal.
And Chiara, you have a reaction?
Yeah, 3 points. One is, I think it's really a useful thing to remember that you are not hamstrung by your hearing dates. Is that the right term? Hamstrung by your hearing dates. And certainly we do find some rigidity when you do at the outset of the arbitration want to focus on that last date, because then you're ultimately working backwards, because as Jan has said rightfully, oftentimes arbitrators do want to fixate on maintaining those hearing dates, and whatever happens in between is fine as long as those hearing dates are maintained. And so not being hamstrung by that, I think, is a useful reminder. I would add an additional CMC to Jan's proposal, or Jan's structure, being one, the first one, the second one, but also what has been deemed an early opening or a Kaplan opening, so to speak, whereby you then get right before the hearing where you have an opportunity to make an opening statement before the tribunal, before you get into the merits hearing. And that can oftentimes be helpful for really further distilling issues. To unravel the issues that are to be determined, and whether they are in a staged approach or bifurcation, etc. It's very important to make sure the issues are worded correctly and well thought through in the way in which these issues are worded, because oftentimes if there is a vagueness in the issue drafting, this could then come back at a very late stage before the hearing of those particular issues, be then addressed by oftentimes a responding party, in my particular experience, whereby the respondent will then say, well, we didn't mean this necessarily, or, we'd like to tweak, or we didn't acknowledge this aspect of it. And so then you'll find yourself unraveling a bit. And sometimes this is a guerrilla tactic, but other times it is because of poor drafting of the issues. So one must be reminded to focus on exactly what is being captured in the issue as drafted.
Yeah, I guess there are always lots of permutations of the same theme. So I guess I was going to mention the Kaplan opening, but I'm not sure that I would have put it as another step as opposed to the CMC that Jan was talking about. But I always thought of the Kaplan opening as being after the first submissions, but there was a hearing date already in place. Whereas, that's an idea, don't have a hearing in place until you've actually had that conversation after the first submission, so you have a better sense of what's really required going forward. So, there are always a lot of permutations on the same kind of theme. And I think we are beginning to see a lot more pickup on the Kaplan opening, which, as I say, it was Neil's idea. And it really was the idea of having a real sit down with the parties after the first submission, maybe before documents, maybe after documents, depending on what, but before the final submissions, to really talk about the case. Spend a day or two talking about the case, sometimes even have the experts come in and give a little preview, and really think about what needs to be done going forward. I know somebody in New York just did it for the first time, and he said the case settled 3 days later. So it can be a very effective tool for informing the parties, about what's important in the case and what the arbitrators are thinking. So anyway, something to think about.
Maybe, Edna, just to add on, you just mentioned the experts. I think that's also a good point in time when you have the first rounds of submissions in to see, okay, what are the technical issue, the accounting issue that you really need to get your head around as an arbitrator. And maybe then you can also agree on a kind of a teach-in. So that you say the two experts get together and say, okay, this is not controversial, these issues, but we want you to get up to speed with the industry. We want to get you up to speed with the economics and all these things that you want to see in arbitrator, but often the arbitrators don't have, or you don't know what kind of pre-knowledge they have. So you want to get them all on the same level. And then to say, okay, is that now a point in time that we can identify issues for experts to teach in?
Good idea. Okay, Dominica's on next, continuing communication.
So picking up on what Jan and Chan just said, I am a great believer of regular CMCs. I don't think the first one by no means is enough because it's really for the procedural rules and so on. The second one is very important because by that time, the arbitrators have more knowledge about the case, counsel have the same knowledge, the parties have been able to assess again whether they want the cost of a full hearing or whether they should still consider the benefit of an earlier settlement if they want to keep their relationship with the other party, for instance. So then I tend to organize now, and I was influenced by my experience during the pandemic, where it became very easy to have CMC regularly on screen, if not always in person. And I tend to propose CMCs almost every stage of the hearing. Towards the end of the deadlines that the parties fix for document production, I usually propose a CMC. Usually parties accept, sometimes they are a bit astonished. We invariably find out that there are issues that suddenly they are very happy to be able to put them on the table and we discuss them, we try to find solution. After the second round of submission, if you had a Kaplan opening after the first round, it's really a very good tool to move on, but some parties do not accept that because they don't want to disclose too much. There are all sorts of strategies going on. I think the CMC after the second submissions, before the hearing, is essential because the arbitrators by then have an idea of what they consider as relevant. And during that meeting, they can, without prejudgment and taking all, the precautions which are necessary, they can ask questions, suggest again, is there perhaps some issues we can evacuate before the hearing? Do we need to spend 2 days on this technical issue? Is it really essential for this dispute? Can we get the experts to meet and submit before the hearing a joint report on each point they agreed about, each point they disagree about? And when I do that, I ask the expert to also propose a solution when they disagree. What is the solution? Usually experts work extremely well together in this way. Sometimes the parties, or maybe counsel, I don't know, intervene and ask them not to go too far in what they agree before the hearing, because they want some witnesses to be heard or they want more document. And this goes on even until after the hearing or at the end of the hearing, where we don't necessarily just discuss post-hearing brief, as we always do, but recently, especially in very complex cases where the quantum of the damages is really extremely difficult, where you had specialized experts who have made tons of programs, charts, you have a desk top to make your calculation, you have complicated issues, which I think one of the most complicated issues for arbitrators is the calculation of interest in some cases. When you have multiple claims, it can be a real headache. You have to decide if it is simple or not interest. There recently, I came across a suggestion by one of my co-arbitrators in a case who said, why don't we, I've done it in the past, why don't we ask the parties to agree that we can have free access to the quantum expert after the hearing, after the post-hearing brief. They sign very strict confidentiality agreement. And once we have made our decision as a tribunal on the principle of the liability, then we did it recently. We spent nearly 3 weeks because it was so difficult to make the calculation with the two experts of the two sides, to which we said, okay, assume X, Y, and Z for claim A and interest X. So what is your joint calculation of this? So they had to sort out between themselves what was reasonable. Usually they do. And eventually they came up after 3 weeks with numbers for all the claims. And it worked extremely well. The parties agreed to that. Again, to be creative and to use the flexibility that Jan mentioned, it requires the parties' agreement. So it's really key to get them on board and to make proposals which make sense to them. And then if you do, I was surprised by the parties' reaction in this case. I thought they would resist. They first started to say, we have never seen that. What do you mean we've never seen that? And it is their client who pushed them to accept it, because probably they were more aware of the difficulties of this calculation. And thanks God we had this, because I think the three of us, had come to the conclusion that we were incapable, in real fact, to really make these calculations precisely. So we could take shortcuts and say, well, reasonably, like in Swiss law, it's according to the reasonable course of event, the judge can decide it's 40%, but it's not really satisfactory for the parties in such cases. So that's one way of being practical and a bit innovative during the course of a constant discussion with the parties during the case.
David?
Yeah, so I fully agree with Dominique that it's critically important for the arbitrators to stay in touch with the parties and to be involved with the parties throughout the case. I think we've all had far too many cases where you see the arbitrators at the first CMC and then you see them again at the hearing. And when you get to the hearing, then they sit quietly during the opening, so you don't know whether they've actually read the papers that you so carefully drafted or not. Either that, or they've already come to a decision. Neither of those is a good is a good prospect, unless of course they've come to a decision in your favor. So I really do think that given the tools that we have now that we didn't have 5 years ago, it's incumbent on arbitrators to do that. And I think that, frankly, the parties are going to start choosing arbitrators who are going to be more interactive, who are going to use these tools, who are going to be in touch with the parties regularly. Just quickly on a couple of the specifics that Dominique mentioned, we've used that technique of having the arbitrators work with the experts in doing the financial calculations on a good number of cases, and it's vitally important. Arbitrators don't know how to run a DCF, so what they do if they're not doing that is they say, well, maybe this factor is a little lower and this factor is a little higher, so we come out with this number, which could be completely wrong because they don't understand how the factors work in a DCF. So in fact, I think I did that first in the Occidental case, which was the first investment treaty case with an award over $1 billion. And that was part of our making the tribunal comfortable that they could give an award like that. We asked them to, once they've decided liability, to give the factors that we were arguing that would go into the DCF to both of the experts and let them do a joint calculation. Of course, they did come up with the same number. And that gave the arbitrators a lot of comfort. So I think it's a tool that ought to be used more often. How the parties are involved and how much of the communication they need to see, I think is something to be discussed. But it's through, again, this kind of iterative back and forth process using the flexibility that we have. Dominique did mention at the conference immediately before the hearing, but Edna, I think you've got that lower down on the list, so I'll come back to that a little later.
Yeah, I just want to pile on a little bit on the expert thing. Yeah, I guess I never think I should do the math by myself. I had one of my co-arbitrators say, why don't they just give us the model? No, you do the model, we'll tell you what the assumptions are. I sometimes ask them at the end of the hearing, I ask the experts if they would be willing to make themselves available to the tribunal later. That kind of takes it, it's going to be harder for counsel to say, no, they don't want that. So I sometimes do that. Often you can come up with what the assumptions are and give them several different variables so they can do it on their own without coming directly to the tribunal. So they present their numbers before or just after the post-hearing argument. If you can give them not too many variables, so it's not too expensive to run, but enough so they don't quite know where you're going if you don't want to tip your hand too much. But I am a real advocate of not doing your own math and not running your own model. You've got experts for that, whether you're ready to use them before the case is over, basically, or whether you need to work with them before you issue. So anyway, all right, next we have Jan talking about some very interesting, more Germanic tools that I think are, Jan thinks that we're not going to want to do them, but I think they are gaining in the ascendancy. So I think you should hear about them.
Yeah, I think a lot of German litigation lawyers think that's a unique selling point. It's the kind of the requirement that comes from the core practice that judges in all stages of the case should help the parties to settle the matter. That's in the Civil Procedural Code, and that has made inroads into the arbitration rules. For German parties and their lawyers, this is very normal. They have a proactive arbitrator who has read the file, has made up a kind of initial views on the case and shares them with the parties. Non-German parties might find that very odd. And this is why the DIS rules expressly require the buy-in of all parties before an arbitrator can do that. So rest assured, this is nothing that will haunt you if you have a German arbitration. But that's the practice. But how do the arbitrators come up with that solution? It's not like splitting the baby or being very arbitrary, but there is an underlying analytical method that every German lawyer gets to know in their training. The German training is you go to the law school and then you spend 2 years with the court and then you learn methods, how judges approach their cases. And that's a very, very old technique that has been applied for many hundreds of years. It's very simple. So what the judge does, they look at the pile of the submissions from the claimant first, and they say, okay, what do they want? So the prayer for relief is very critical. That's the finishing line you want to cross. And the question is, how do you get there? And you need some legal rules. And for the legal rules, you need factual allegations to meet the tests. So the judge looked at the submissions and say, okay, if I just look what the claimant has stated and I take it for granted. So I'm not questioning, it's not relevant whether that fact is disputed or not. They just take it for granted and say, if everything is as the claimant alleges, does the claimant come to yes? Does the claimant tick all boxes? And in that exercise, you already maybe see, okay, well, maybe the legal test, the contractual provision doesn't quite give you what you need because we take maybe a different interpretation on it. Or you've missed to give a specific allegation. So there's a hole in your line of argumentation that you need to establish. These are then points where a judge could give a notice to the parties. They say, well, there's something missing, you need to fix that. But normally, all the boxes are ticked. And then the judge turns to the submissions of the respondent, and he does the same exercise. Everything that the respondent denies, he takes as being the facts. And then he analyzes the case and says, oh, are the defenses relevant? Do they bring down the claim? If everything what the claimant has said will be established in taking of evidence. And if the judge says, okay, that's the case, then the judge knows exactly where are the points where there's disagreement, And then they will see, okay, these are the points where certain things are disputed and they are junctures that are relevant. So we need to take evidence to identify, is the narrative of the claimant right or is the narrative of the respondent right? And that's a point in time. And they're not prejudging the evidence, but they just say, okay, in my analysis, I have the following legal issues. You know, we need to talk about it on an abstract level. And the German lawyers like abstract views on things and say, okay, we can talk about this and we can engage in a debate and it has nothing to do with the facts. And then the judge also says, okay, but here are certain issues where the case turns in that direction or that direction. It all depends on the taking of evidence. So what the judge normally does, or the German arbitrator said, well, we talk to you about where do we stand in our analysis at that point in time. They're very transparent. They summarize the facts as they understand them. They say they give the legal issues that they identified in their analysis. And then you have a basis also for settlement. Because then the parties see, okay, the judge or the arbitrator sees issues here. And maybe upon reflection, you see, okay, it will be very difficult to bring this point home because my evidence isn't good enough. Or I see, well, the legal test, maybe my legal theory or my analysis, my contract interpretation will not fly. So do I have an alternative route to get to the finishing line? Or if I don't have it, maybe you reconsider your chances of success. And then it's a point in time where you can also go back to your clients and say, well, isn't that an idea to settle this? And potentially in a German arbitration, the arbitrator would be willing, if both parties buy in, to help you settle. And even make a settlement proposal. Say, on the basis of our current analysis, we think, you know, a good solution will be to do X, Y, Z. And that's a very efficient way of getting the dispute resolved. And also a very efficient way of the parties to learn where at that point in time of the case, the judges stand and the arbitrators. What is their thinking? So do I want to have the black box arbitrator? So I open the arbitration award, look at the last page and say, hey, great, I've won. Or you say, oh my God, something went wrong. But you didn't know in between because you always had the poker face. Or is it better that you engage with the arbitrator and hope that you can convince him or her and say, well, actually, you've missed the point. But you always need to build bridges so that they can get out without losing face. Like, say, you got it totally wrong. But you know, there are a lot of ways as an advocate to do that and to help them. But to know about it, and I think that's the German Relationstechnik. It's a relationship. You put the two positions into relationship. And then you'll see, okay, what do we need in terms of taking of evidence? And you can narrow it down. So if you have a German court case, you have hardly more than a day of a hearing. It's not like an arbitration, 2 weeks, everybody's talking about everything, doing cross-examination on points that's not really relevant for the decision maker. But you just feel this is necessary to bring the witness down in cross-examination. And that's a situation where a lot of German litigators and arbitration lawyers and the parties, they find arbitration too complicated, too lengthy, and not really focused enough on what really matters.
So I think, you know, while you thought there might not be much pickup on this kind of idea in this part of the world, I think David has been talking about decision trees for a while as part of his town elder and now in real protocols for the town elder. So David, you want to pick it up? Because I know this is a little bit along the lines of what you're talking about these days.
Sure, and I'll say that I have, even as both as counsel in cases and asked the arbitrators at times to give us some preliminary views if I thought it would help get our client and the other side to settlement, and I've done that when I've been sitting as an arbitrator too. As Edna mentioned, the town elder paradigm that I wrote about 15 years ago was basically saying that, you know, in 3,000 years ago when arbitration began, and the parties would go to a town elder, the town elder wouldn't say, here's my procedural order number 1, I'll see you in a year and a half after you've taken all these steps. The town elder would ask each party, what's this about? What do you know, tell me what your complaint is. Tell me why you think they're wrong. How are you going to tell me how you're going to prove this? Tell me why that's wrong. Who might have actually witnessed this, and build the case up from the beginning. And that's what we all ought to be doing in terms of using our experience in international arbitration to sort it out from the very beginning. And I think that's a common theme you've heard up here. And then the next step, or another way of going about that, is to see in certain cases whether a decision tree approach is the right one. And it's very similar to what you were just describing. It's looking at where the issues may come to a critical junction, that if it were a legal issue or a factual issue were decided in a particular way, it'll take the case in a different direction. So last year I published what I call the Town Elder Rules, which were basically a set of rules by which the parties could develop a decision tree, working with the arbitrators and the arbitrators with the parties. At the very beginning, a decision tree to work through the case. And it's not right for every case, of course. But there are certainly cases where we could save a lot of time, and where if the arbitrators determine certain issues early on and in certain ways, the parties will then be able to come up with an appropriate resolution themselves, and you won't actually have to go through the final steps of the decision tree. So I think this is another tool in our toolbox that we need to use more often. Not always, of course. None of these should be used always. It should always be what's appropriate for the particular case.
Always bespoke. All right, so I guess, Chan, we're going to talk about something that's quite unusual, which is hot tubbing fact witnesses. What do we have to say about that, Chan?
Yes, certainly we all know that hot tubbing exists with some reasonable frequency amongst experts, but this idea that we have discussed amongst ourselves is the concept of hot tubbing fact witnesses. And the idea is really, I think, to put witnesses in front of together and then in front of the tribunal. There are several advantages I think one could imagine in this type of circumstance. One is the fact that you have two main witnesses sitting next to each other does have psychological impact on what comes out of their mouth, how they testify, the veracity and their credibility, and lots of certain attributes that in person, putting yourself in front of the other person who was in the room at the same time, or living that dispute or living that relationship as the relationship unraveled, can have some interesting benefits. The other aspect is in relation to the questions that the tribunal would put in front of the two fact witnesses. Certainly, we all are very familiar with cross-examination, and certainly what we see is oftentimes a very pointed exercise at seeking out certain admissions from the fact witness. But this exercise would have a very different experience in that it would really, for the tribunal, have the exercise of drawing out the truth and drawing out exactly and trying to put the different missing pieces together that one might not see on the record. And so the exercise of doing this fact witness hot tubbing could be useful in achieving these types of gap-filling exercise, as well as credibility of the fact witnesses. It hasn't, in my experience, I have not seen it, but I have certainly heard of it from time to time, and I would be very interested in hearing actually the experience of those in the room, as well as certainly on my panel as well.
Dominique?
Hot tubbing fact witnesses, in my experience, is a very difficult thing to do. Firstly, we all have different views about whether it is necessary and really helpful to hear witnesses in some cases. When the documents are clear, there is not often any need to hear witnesses. We also all know by now, we have all learned that memory fails most people, and that people think that they remember that, but in particular after they have been rehearsed by counsel. I mean, it's no longer the case as it was in traditional Roman law and civil law, where the witness will come virgin in front of the judge who would ask questions, and then it would be really the witness recollection in his or her own words. It's gone. The witness statements are almost like brief. I think it's interesting to give background to the case, to show the arbitrators how the industry works and how the relationship works. But in terms of strict evidence, I think, in my opinion, it's a little bit on the lightweight side. So when you put two witnesses together in a hot tub, I had the experience only twice. The first time, it was absolutely unannounced. The arbitrators decided suddenly we're going to hot tub the two main witnesses. We had to recall them. They had already left. And the arbitrators then said, and you, counsel, you're going to put the questions. So that was very strange experience. And I remember that I had, not knowing what to do, I did what I felt I should do. And in the end, the witness of the other side looked at me and he said, I really like your question. We should meet at the bar after which ended up really not very nicely because my counterpart opposed and all sorts of questions. And honestly, there was no preparation on my part. I was taken by surprise, as was anybody. And after that, I thought I will never have this experience again. And yet, it was imposed on me once again. And there, the arbitrators did their work. They put questions, and it was one of these cases where it's the word of one person against the word of another. It was completely black and white situation, and of course there was no document on this particular point. The witness on our side, we thought, had been very well trained, of course, and was very credible. And we thought that the witness from a civil law country on the other side, who had not been properly trained, was not credible at all. But when the two of them were put together face to face and the arbitrators started to put questions to them, our witness lost the plot, so to speak. The other witness lied, apparently, I'm told, I don't know, but without any inhibition, like some politicians know how to do. And honestly, it was almost shocking. And he said things, even the counsel on their side were a little bit surprised. And our witness was so shocked that he lost all his means of appreciating. He couldn't believe, and he started to be really not credible. He said almost incredible issues. And the case was lost on this particular point in the award. So it was a very sore memory. In retrospect, as counsel, I would never have accepted again without notice and preparation and in-depth discussion on how we are going to do it, who does what. And as an arbitrator, I would not impose that to counsel as I was imposed. It may be that it could be useful to have the two together. And I think you had this experience, Edna, in a case.
I've done it once, and I think it worked really well. You know, the one person who really advocates for this is Jeremy Lack, who was here last year. And he said, you know, because people have so many false memories, you know, not on purpose, but they're not lying. They just remember things differently, or they've been prepared, or they've seen documents, and creates a false memory. And he said he's had several occasions where he is hot tubbed, and he is very partial to this process. Hot tubbed fact witnesses, and one of them says, oh, you know, now I remember you're right, you know, because they begin to remember different facets of the past. And, you know, how many witnesses actually confess to it? I suppose how carefully counsel has prepared them. But he finds it very effective. It worked quite well on the one time I did it. You know, there were two Chinese parties, and I really thought that they were going to want a Chinese kind of process. So I actually suggested that we do an Arb Met Arb. And I think it worked really well. You know, we settled, you know, we did the hot tubbing fact witnesses in the morning. I essentially mediated it in the afternoon. It resolved. We did a consent award. And I think everybody was quite pleased with the process. But, you know, it's not for every case, but, you know, these are all unique tools that might be good for particular cases. Everything's always a bespoke process. So, you know, think about it if it's right for your case. I would not force it on counsel. I agree with Dominique. I mean, that's got to be something that they agree would be a good idea in the particular case. I would not force it, for sure. Anyway, okay, last question, and then we're going to have some broader questions, and then we will invite some audience participation, I promise. So David's going to talk about providing a draft award.
Yeah, so this goes back to a point too that Dominique made earlier about the CMC right before the merits hearing. By the time you get to a merits hearing, however you've structured the case, the arbitrators have received a lot of information. They've seen the arguments, they've seen the factual evidence that the parties are relying on in their legal arguments. One way or another, if they've read the papers, arbitrators are bound to have started to come to some idea about how they might rule, and or at least the issues on which they see the case turning, and what's important and what's not important, and which witnesses are going to be important and which witnesses are not important. And so as counsel, we have begun to try to write into the original procedural order that the arbitrators would conference, we won't call it a deliberation, but a conference at some point after the last set of submissions and reasonably before the merits hearing, so that they can talk about the issues. This serves a couple of purposes, including making sure that the arbitrators have actually read the papers before you get to the hearing. But then to have after that a CMC with the parties, a pre-hearing conference where the arbitrators can really give some preliminary views to the parties. And you can write into the procedural order that the parties agree to this so that there's no issue later on about prejudgment or something that could be used to vacate the award. And provide some real guidance to the parties about what they want to see in the hearing, which witnesses they view as being important, what are the issues that they see it turning on, and some preliminary views about this part of the case is strong, this part of your case is also strong, this is weak, I need to understand this a little bit better. It will be so much better for the parties to have a hearing where they actually know that they are trying to deal with what the arbitrators are thinking instead of arguing to a black box and presenting evidence in a black box. And of course, the parties will have some flexibility. If they think that arbitrators have missed something, they can still present a witness or cross-examine a witness on a certain point that they think is important that maybe the arbitrators didn't. But there needs to be that kind of again, iterative work, back and collaborative work between the parties, the counsel, and the arbitrators to make the hearings, which are time-consuming, they're costly, to make themselves so much more efficient. And you can step back from that and talk about, there's been some talk about the Kaplan opening or other CMCs in the middle of the case. Again, the same thing could be done after the first round of submissions and before the second round, where the arbitrators could say, we know we haven't seen your replies, but here's where we think the case may turn, and to really help the parties focus their second round of submissions on the issues that the arbitrators are going to think is more important. Now, Edna mentioned a draft award before the hearing. I know of one judge here in the Southern District who on occasion will give the parties where she's sitting on a bench trial, so it's not a jury trial, give them a draft decision based upon submissions that are very similar to the kind of submissions that we have in arbitration. And if you think about it, there could be some worry about confirmation bias if somebody does that before a hearing, and I get that. On the other hand, whether it's through that precise a process or the more general but still detailed process that I was talking about, I'd much rather know if I've got a steep hill to climb with the arbitrators, I'd much rather know it before the hearing and think about how as counsel I'm going to try to climb that hill and convince them that they're not seeing an issue in the right way. Obviously, if I'm on the right side of what the arbitrators are saying, I want to find every way to use the hearing to reinforce that and to prevent the other side from turning it over. But it can be so much more effective a hearing if there is much more substantive give and take. And the arbitrators don't need to worry about this being used as a basis to vacate an award after the fact, because it's all done with the parties' consent right from the beginning.
Jan, did you want to add something?
Yeah, I would suggest that you would probably like a German judge in litigation, because this happens there. at the hearing, the judge introduces to the facts and the legal issues. So he must show that he has read the files, or he or she has read the files, and that they've done some analysis. But recently, I'm sitting in and chairing an SSC arbitration where everybody is Nordic except for me. And the first point on my agenda for the case management conference is my expectations of the parties on how the arbitration should be conducted. So when we deliberated before that CMC, I asked my co-arbitrator, I said, well, is there anything I could expect that they may come up with that they want? Because this is Nordic. And he said, well, maybe it can happen that they ask you that you prepare a written arbitration award before the hearing. Not, of course, going into assessing evidence, but just to summarize the positions and the kind of, you can do the procedural history. Everything can be done so that at the end, after the hearing, you just need to add a little bit, namely, okay, we're following that narrative or that narrative, and then this is the result that comes out. At the CMC, the parties didn't request for that, but that was something really eye-opening. And you know, there are so many traditions in domestic arbitration or litigation that we are no longer looking at, and we are having this obsession saying, well, international arbitration needs to be international, so don't look at litigation practices. But there are so many tools out there which are really worth to explore and see, is there something we can import? Not saying, okay, now we look at Swedish civil procedural law, but say the idea to have something in draft, why not?
Yeah, I think that's one of the beauties of international arbitration is we do pick up pieces from all the different systems, whether it's from courts or from other arbitrators and other systems, and be able to apply them in the right case, in the right circumstances.
You know, just a moment on preliminary views. I used to do a lot of talking about unconscious bias and decision-making. And one of the things I used to talk about a lot was confirmation bias, which David mentioned briefly. And so there were two occasions where there was a German arbitrator in the audience, two different German arbitrators. And on both occasions, they got up and said, no, that's not true about confirmation bias and preliminary views. I changed my mind once after I gave my preliminary view, which I thought kind of confirmed my concern. Anyway, so I'm not saying don't do it, but I'm saying be really careful about confirmation bias, because you know what that means is all you hear is what actually confirms what you already thought to be the case, and you don't, it's not conscious, you just don't hear the other evidence. It doesn't kind of enter into your decision-making, into your thinking. All right, so now we have time for questions. We had a few questions. We're not going to get through all of them, but why don't I do the one about autonomy, which we thought was most important, and I would invite both the panelists to give a very brief response, and then we would invite people to come up to the microphones if they have a response to our question, and we'll see if we can get through two of them. Okay, so here's one. Can we dictate the process we think is best suited to the case, or are we limited by party autonomy? How far can we go to persuade on process design? So David's going to lead off, then everybody's going to have short interventions, and then we invite the audience to say, how hard can we push the parties to do what we think is right for the case?
I think we can push them very hard. Arbitrators at the beginning of a case have an awful lot of persuasive power. You don't want to upset an arbitrator at the beginning of the case. You don't want them to think that you're afraid of it. I think arbitrators have a lot of ability to encourage the parties to move in a certain direction. As several of us said earlier, that is particularly enhanced when you have the actual parties there at the beginning of the case, because they want this case to be done efficiently. They're paying the bills. They don't want a case to drag on. So it gives, if the arbitrators can talk sometimes past counsel to the parties, again, you can get to a point where people are actually agreeing rather than having something imposed. But if you need to impose something, most of the arbitration rules these days have been revised in such a way that it makes clear that the tribunal really is the one in control and can make decisions, which helps a lot in terms of avoiding a setting aside on the basis that some procedure wasn't followed or was done over the objection of a party. And finally, just to reinforce that, I commend everyone the IBA study that was done a few years ago about cases that were decided on preliminary issues or dispositive motions, where the arbitration committee surveyed court decisions in many different jurisdictions around the world, common law, civil law, where courts unanimously upheld awards and refused to set aside awards, where the arbitrators decided that a case based on some subset of issues in the case, because those were the issues, or that was the one issue that was indeed determinative of the case. National laws all require that arbitrators hear the evidence and arguments that are relevant and material to the decision. And if there's only one issue that is in fact relevant and material to the decision, there's no obligation on the part of the tribunal to hear evidence that is relating to other issues. And so this IBA study, when the committee first did it, we hoped would give arbitrators a little more backbone in being in pushing appropriate procedures. I think it has helped, and I do think again that the pandemic and the need for saving time and cost are all going to push more and more arbitrators and parties in this direction.
Others, what's your reaction? Quick interventions. If anybody in the audience has an opinion, we'd be happy to hear that as well. Anybody else want to chime in? I have some. Go ahead.
I think that I completely agree with what David said. I think we can be as persuasive as we can. In the ICC rules, for instance, in the commentaries, the ICC states that it is good practice to invite the parties to make comments on what you suggest, of course, and ideally to get them to agree. And if they cannot agree, then the arbitrators will decide. They have this power under most rules and under most laws. But under some laws, it is still provided that the arbitrator has to decide in consultation with the parties. It doesn't mean the parties have to agree, but they have to be heard in order to lead to a waterproof award.
I'm certainly not suggesting that the arbitrators do it on their own. This has to be a process with them.
Yes.
But in the end, I think the arbitrators have power to make a final decision.
You know, I just want to add, I think you do have a lot of persuasive ability at that first conference. I think they are trying to make you happy and make you like them, so they tend to be more cooperative. So I think you do have essentially a bully pulpit. But I think I always think about two stories. And so it was one of our colleagues here in New York who ended up being an arbitrator in a case. And the reason he had the case is that the prior set of arbitrators had dictated the process. And the party said, well, we don't like what you want to do. They were in agreement as to what to do. The arbitrator did not agree. They said, fine, we'll just get a different set of arbitrators. And so they did. They just switched arbitrators. And I've heard similar stories with some judges who had just come off the bench and they don't realize this is a different process. And so they just dictate what it's going to be, when it's going to be. And the lawyers say, you know, we can't do this. And so, you know, they just go and get a different arbitrator. So I think, you know, you do have a lot of persuasive abilities, especially at the beginning of the case. But, you know, ultimately, I guess I think party autonomy rules. So depends what kind of thing you're thinking of dictating in terms of whether you think you can do it or not. But I think one needs to be a little bit sensitive to the idea of party autonomy if you want to keep that case.
And I think just to add on,
Yeah.
if you come up with these kind of innovative ideas that we are discussing, I think you need to be very careful. You should not impose any of your hobby horses on the parties. At the same time, you can nudge them, of course, in a direction, and you can do that. You talk about it and say, okay, let's have a conversation about it. That's an idea that I have. Or maybe even, I just did that in a case management conference. We said, we want to get outside of the boxes of your request for arbitration because we cannot help you. So we'll give you 2 weeks time, we come back. And then we talk about it, think about it. Whether it wouldn't be smarter to just come up with a new arrangement, and then we can operate within a new arrangement rather than just going through the motion of an arbitration that won't give you anything. And well, the parties are still out there, but I do have the hope that they come back with something smart as we nudge them. But it's nothing you can really impose on the parties.
Great segue to our next question, which is, will counsel/parties and arbitrators accept innovations? How do we start moving them in the direction of some of these techniques? What are the impediments? Because I think this is actually not an easy transition for parties, arbitrators,
party representative. So Chian, you want to take the lead on that one?
Yeah, certainly, I think it is somewhat helpful to have these conferences where we talk about it, but it's another thing for us to really, as a community, embrace all of the different aspects of the innovative ideas or the alternative ideas that we've been discussing today. One thing that I have, time and time referred to are institutions and the kind of information that they have to offer or not offer. Obviously, institutions are now bound by many layers of confidentiality, but they are the kind of data that they have at their disposal could be hugely informative in moving the dial on some of our behavioral practices. In particular, I think certainly knowing about the statistics of number of arbitrations oftentimes influences parties as to which institutions to choose. But why not have more metrics on number of mediations, the number of settlements, the other aspects of the dispute resolution process that helps us understand better how often mediation is being used, how often other forms of ADR are being used, who is executing, who are the mediators. We certainly don't have the kind of extensive lists and panels that we have for ADR experts in the same way we do for arbitrators. And so one way would be to really engage with that process from a much more transparent sort of way.
Yeah. Anybody have anything to add? The audience have anything they want to say about anything? Okay, we got one taker.
Peter Pettibone. The utility of inserting a mediation into an ongoing arbitration, do you find it to be a good item for the toolbox? And if so, how does it get done? And when does it get done? Does it happen in the beginning, the middle, towards the end? Obviously, if it's towards the end, you really don't save much in the way of time and costs. But how best to implement that?
Somebody want to take that, or should I?
I was going to say the answer is yes. It can happen in any of those times. It depends on the case and where it is, and if the arbitrator, and again, I think the arbitrators have to have enough knowledge about the case to make the suggestion about it, and perhaps offer to give some preliminary views that might help as well.
Yet there seems to be somewhat of a conflict because both the tribunal and counsel have a strong interest in proceeding forward with the case. They know the case, it's their case. And to bring in mediation, particularly to bring in an independent mediator, abrupts that process. How do you overcome that?
Well, I don't know. So, if it's a parallel process, I guess I'm a real believer in the mediation window and suggesting it to the parties. I used to do a lot of court-ordered mediation. That happens very early in the case, and one would think that they wouldn't settle, but frankly, they do, and they settle. The court order and the ones that are voluntary actually settle at the same very high rate. But a good mediator is going to stay with it. So they may be starting at the beginning of the process, at the beginning of the arbitration. But if it doesn't settle then, that's not the end of the story. One of the cases I really wanted to hear, it was a Madoff case. It would have been the real, the red flags, should they have known? It was like such a juicy case. So the mediator was Eric Green, who's an excellent mediator. And the case settled the Friday before the Monday that was supposed to start. And I was sitting at an arbitration with him years later, and he said he worked that case for 2 years until he managed to settle it the evening before the arbitration. So I think, throughout is the answer, and the mediation window in terms of when I suggest it, it can be early and continuous. You can have lots of mediation windows. You can have one mediation window. You kind of talk to the parties about what that mediation window should look like. Is it going to be a pause in the process? Is it just going to be a time to talk about whether you want to mediate so it doesn't actually interrupt the process at all? There are lots of permutations on the mediation window, which you can talk through with the parties. I'd say in my experience, a third of the parties say, we don't need it. We're really able to talk to each other about, without any kind of intercession. A third of the parties say welcome the idea and they build it into the schedule. And a third say, been there, done that, not interested. But I think a third is pretty good. So, if a third of the people are going to be at least considering mediation somewhere along the process is a positive, I think. Any comments? Yes.
Good afternoon, everyone. Stephen Warrior is my name. LLM NYAW 2014. My question goes to Mr. Rifkin. Particularly in the area of the Town Elder model revisited. You wrote a paper back in the days where you talked about towards a new paradigm in international arbitration, the Town Elder model revisited. And in that paper, you had canvassed the position that we should go back to the basics, where the arbitrator simply takes a step back. You define the rules, you give the parties the opportunity to make their presentation, and you reach a decision.
You take it.
But in recent times, we've seen scenarios whereby the arbitrator tends to play a more active role of not just only having a CMS where you discuss the issues, the lay of the land, the way forward, but you try to encourage settlement. You try to encourage parties to resolve their disputes. Now, my question is, how do we reconcile these two positions? Because one would argue that one is best suited for a mediation process where we've identified the issues and want parties to freely think about it and then work out a solution. But for the street arbitration process, it's business. So you place your cards on the table, I place my cards on the table, and the arbiter reaches a decision one way or the other without getting involved in helping you resolve the disputes.
So
This is sort of what we were talking about over lunch. Somebody want to take it?
Well, I don't think there's actually a contrast between the town elder model that I proposed 15 years ago and what we're talking about here. They both involve a lot of interaction between the arbitrators and the parties about what's the best way to proceed in that particular case, not to be bound by a standard procedural order, number one, and even to have flexibility to change the procedures midstream if that's what seems to make sense once everybody knows more about it. And it's a back and forth process. It's, as I said, the town elder, it was always a he 3,000 years ago, would be talking to the parties and try to learn a little bit about the case, and then propose ways forward, get reactions from the parties, and find what the right procedures were, who might actually have some evidence that would be interesting, and so forth. And I think all of the interactive models that we have talked about here are all very consistent with that kind of back and forth approach.
But just one quick point. What I understand the final conclusion to be is to achieve an expeditious determination of the arbitral process to get an award as against having a settlement in between. I might be wrong on this point.
Look, I think our obligation as counsel and our obligation as arbitrators is to provide is to get the parties to an effective and efficient resolution of the dispute. Okay. And that may be taking it all the way through a hearing, but doing that efficiently, or maybe finding a way to get certain issues aired early enough that then the parties can find a way to settle. So again, I don't think there's any contradiction there.
Dominique?
We were having this discussion at lunch, and I was saying that I had recently, a year ago or so, the experience of a co-arbitrator who was reluctant for us to try to push as much as we wanted to be innovative and to find tools to reach a settlement too fast. He liked the idea, but he said he was afraid that the law firm which had appointed him wouldn't be too happy, and he was feeling slightly uncomfortable that we would go too fast. So obviously I never thought about it before, but maybe for some arbitrators there could be a business concern. Who knows?
I just want to say, while we're on novel ideas, this is something Dominique also said over lunch as we were chatting. And she said she had one case where the arbitrator had everybody eat together, which I thought was very interesting. So Jerry Axon would never do a mediation unless he had a dinner the evening before with the parties, no lawyers, no talking about the case, just to get together. And I used to think in terms of, it's the first time these principals might be seeing each other since they had a dispute. So I used to think, how you set the table, that's very important in a mediation rights. I thought the arbitration, if I set up the room differently and I sit on the side instead of the head, I can insist the two principals sit next to each other across the table, right? So that was pretty creative, but I think this is more creative. A meal together instead of separate. I don't know, one more innovative idea to throw out there for an appropriate case where, really is the principals and maybe they haven't spoken, and maybe this is really an opportunity for them to converse and maybe settle the case. So I don't know.
I think we speak of new tools, but I think this experience Edna mentioned, I had it several times because I worked a long time ago with a maritime arbitrator, Cedric Barclay, and he was used to the old days in England where arbitrators could issue awards without reasons. So he had developed all sorts of techniques to show that justice was being done. And one of them is that everybody knew in London that this would happen. There was lunch, and he would change the sitting plan during the morning, depending on how things were going. He sat everybody, we couldn't choose. Always there was wine, good food. And and we were not allowed to talk about the case. So as I said at lunchtime, people were invariably speaking of their holidays, Christmas, children, and the new series on it was before Netflix, but on television, And in the afternoon, invariably, the atmosphere was very different. And I was used to that. I was a beginner when I worked with him. And when I went back to normal arbitration cases, I was faced with more traditional arbitrators who told me that he was crazy, that you couldn't do that. And everything became very structured, rules, guidelines. And now it seems there is again this need for the relationship, which was in the essence of arbitration at the time, I was told by Cedric, where people need to see that as the arbitrators that David described, who would show up at the CMC and then at the hearing, and then, as Jan said, you open your award last page to see what happened, and you have no idea. It seems where we pass this stage, and there is a need for more of the old approach, more human aspect of the arbitration.
Does seem like a perfect note to end the session on. So unless somebody has a burning comment or question, I see one over there. All right, so pretend this was the final thing because it was such a perfect ending.
Good afternoon once again. My name is Abiola Orakoya, LLM Tulane 2018, and currently doctoral candidate at the Delaware Law School. Thank you very much, the panelists, for this insightful information. I've learned a lot. My questions are actually bifurcated into two. The first one is with respect to the two leading alternative dispute resolution mechanisms, arbitration and mediation. In a situation whereby in an international contract, for example, there is an arbitration clause and a mediation clause, which one takes preeminence? I mean, which one takes priority? And is it possible to have an arbitration clause in a contract and also a mediation clause? And in the eventuality that a dispute arises, which one takes priority? And my second question is on maritime arbitration. I think one of the panelists just alluded to that. So my master's was in maritime law. And my question is, in the city of New York, to what extent are maritime awards enforceable in the city of New York? Thank you.
All right, let me take the first question. So, generally speaking, the contract will have a sequence. So the mediation typically will precede the arbitration. I guess the two important things to remember there is there should be a time frame so that if the mediation doesn't succeed by X date, you can move on to whether it's arbitration and mediation as opposed to leaving it open-ended. Then people can say you haven't complied with the condition precedent, then you don't have jurisdiction in the arbitration, and not putting in a good faith requirement, because then you can argue about that. And did they really do it in good faith? So typically the contract will set up the sequence and it'll be mediation first and an arbitration or court second. But that doesn't mean that because it has moved on to the second step, you can't continue the mediation as per the example I gave earlier. The mediation can continue after the next step is commenced. Somebody want to take the second question?
I guess I'm the only other New York lawyer here, so I'll do it. Yes, maritime awards are certainly enforceable, just as any other arbitration award. In fact, many of our earlier arbitration precedents in the U.S. were all maritime cases. So yes, they are certainly enforceable, just like any other award under the New York Convention or under the Federal Arbitration Act.
All right, so with that, I think we are going to close the session. We ran 15 minutes over, so I hope you are not upset with us. But there is a very nice reception outside. Please stay. We would really like to mingle with you. We're, of course, available if you have more questions. And Benno probably wants to come up and say something. And it's, by the way, it's CAP 22 again. Well, you beat me to it. I didn't get to thank our excellent presenter. So thank you all.
Our thanks to this panel. It was fascinating. It was a great day. We really enjoyed being in person with everyone. I can't tell you. It seemed like this day wouldn't come. We need to thank our friends at Fordham, Chanel Holly and Morgan Benedict, who worked with us over the years, who do a magnificent job in doing all the things to make this possible, and their colleagues who are in charge of events here at Fordham. We really are grateful to you, and you really deserve a big, big hand. And I should say, and this goes without saying, it's Professor Jackie Nolan Haley has been our friend and supporter, and is the force behind this conference, and we are grateful, Jackie, as always, for all your help and guidance. So our thanks to you. This is the last event of New York Arbitration Week. We hope you've enjoyed the day, and I think it's only fitting that we close it out with our co-chairs speaking to you about what this week has turned out to be, which is, I think, just magnificent.
Thank you very much, Benno. Daniel and I know how dangerous it is to be between people and drinks on a Friday afternoon. So we will be very brief. As Benno mentioned, this is the final event in New York Arbitration Week 2022. It has been a marvelous week that has been made possible by the extremely hard work of the organizing committee, including Benno. All of the speakers and the organizers of particular days. The Fordham Conference is the third, in many ways, sort of anchor event that we had for the week. We knew it was going to be a magnet for amazing discussions, for participations, for speakers and discussions. But many, many thanks to all of you, because Arbitration Week does not work and it does not happen if people don't come primed with questions and keen to participate in the international arbitration community that New York is so much a center of. So with that, Daniel, want to close out?
Thank you to everyone for a wonderful week. We had 15 conferences, panel discussions, a game show. We had more than 100 speakers from more than 20 jurisdictions. We had networking events every night, more than 200 people at the Skylark on Tuesday, and then very, very successful dine-arounds that Natalie had the idea of. So it was a wonderful week, and what we also feel very good about is that we've engaged with the international arbitration community outside of the United States, the international arbitration community worldwide. We're very proud of New York as an arbitration seat, but not all of the ideas and not all of the solutions are in New York. We've heard about 10 new ideas this afternoon. I'm French originally. I do not know if the long lunch with wine and everybody is something that would fly in New York, but I would really like to see. So thank you to everyone. Thank you to our sponsors, participating organizations. Thank you to NYAW and the Chartered Institute. And I echo Natalie, thank you so much to all the members of the organizing committee who were wonderful in their creativity and drive.